All right, good afternoon. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 11th. We have, I don't know, how many bills we have on the docket today? No. Good. All right, so we're going to start off with where we left off last session with Senate Bill 98, Senator McCray.
So there is an amendment in your packet. It's just a draft amendment. So Amendment 1 is technical. Amendment 2 is what JPR already adopted on, I believe it was Tuesday at the last meeting, which just conforms the Senate to the House version. And then Amendment 3 does two separate things. So first thing it does is, which was discussed at the end of the meeting, it adds in the boost language into the bill on page 4 of the bill. So it specifies that this subtitle does not require a non-public pre-kindergarten program or non-public school to adopt any rule, regulation, or policy that conflicts with its religious or moral teachings. And then the second part of Amendment 3 appears on the last page of the bill, in which it strikes the requirement that the certain schools adopt and maintain a written anti-discrimination policy.
So Heather, just to be clear, we've adopted the first two sections of this, right?
Yeah, so Amendment 2 is already adopted. Amendment 1 is just technical, which is just purpose paragraph. I'll update that as needed.
I'm not paying attention. Are we on the first bill?
Yes. We are on Senate Bill 98, and we're going over the amendments that Senator Castley offered 2 days ago.
Thank you. Sorry.
No worries.
Yeah, so the points at issue before the committee is page 4 of the bill, or of the reprint, and then page 8. Or those are the two current changes that are pending.
Let's talk about the first one.
Yeah, so section 26-702, which is on page 4, line 12, this goes over what this subtitle does not require a non-public pre-kindergarten program or a non-public school to do. So number 1, which is currently in the bill, or paragraph 1, which is enroll, retain, or extend privileges to a student or prospective student who does not meet the usual and regular qualifications, requirements, and standards of the program or school, provided that the denial is not based on discrimination on the grounds of race, ethnicity, color, religion, sex, age, national origin, marital status, sexual orientation, gender identity, or disability. So that's currently in the bill. And then the amendment adds or in paragraph 2. So the subtitle does not require a non-public pre-kindergarten program or non-public school to adopt any rule, regulation, or policy that conflicts with its religious or moral teachings, and that language specifically was pulled from the boost language.
Yeah, go ahead.
So we held this over from the last voting session because we swapped that language out on page 2 of the amendment, and I wanted to have a time to review that, and thank you for that, Mr. Chairman. So that language that had been proposed, I think by the vice chair of the committee, that's acceptable. So that's why that's in this amendment. So I would move the remaining portions of this amendment that haven't already been adopted by the committee. My motion is to accept. So basically, it's Amendment 3, right? That's the only one that's not there. Is that right?
Yeah, so before the committee is the proposal to adopt the amendment to page 4 of the bill, which appears in Amendment 3.
So it's basically just under line 21, just those lines right there, those two lines.
So if the committee does that, then the only portion up for conversation still would be the changes on pages 6 and 7, or sorry, 7 and 8.
And that's the written regulations.
Yeah.
Policies. All right, so is everyone okay with that?
Oh, the whole thing?
I would ask to parse it out so we can have a separate discussion on the second part.
My amendments for both of them, those things were, we discussed this last time. These two are part of an agreement that was struck between the two religious communities, that they would stand on this and support each other in these, and we're trying to now parse those out, and I don't understand why we would want to do that.
I second moving the other as a whole.
So okay, the motion has been made, it's been seconded. I'll resist the amendment. I like the first part, but the second part, I think we need to have a different discussion. So it's been seconded. I strongly would urge my colleagues to reject the entire piece. We could parse this out, but
Yeah, I mean, I'd be glad to discuss it at this point, but we had discussed how the second half that you're objecting to was the language that the Orthodox community had asked for, specifically asked for. It doesn't change what they would actually do. It just doesn't require them to put in writing what they're obligated to do. And I think that's to require someone to write things down that they object to writing down is sort of a First Amendment violation, in my opinion. That we can tell people what to do and we can tell people what they can do and not do, but to tell them what they have to write is inappropriate. And so I think that's more of a thought control thing. So I encourage the committee to support the entire amendment.
no, just to be clear, it would just say that you take the state money, that you just have to develop and publish policies that you don't discriminate. But Senator Sidnor.
I withdraw. I'm fine.
So it was asked for a roll call. A motion's been made. It's been seconded. So, Senator West, go ahead.
Sure, if I were crafting this from the beginning, I would want to take that language out, but a deal is a deal. If in fact it was a deal some years ago, I don't think we should unilaterally abrogate the deal by taking the language out.
A deal.
I mean,
we are not a party to that deal. I mean, I was not.
I know.
Yeah,
But
that's great. They made the deal. They're not sitting in a seat. So, all right. So we'll roll it.
Vice Chair Waldstreicher.
No.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
yes,
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
Yes.
Senator Carter.
Are we voting on the whole amendment? Pass.
Senator Huff.
Yes.
We're voting the whole amendment. It's got the Orthodox Jewish.
Senator Carter.
No.
Chairman Smith.
No. Are there any other?
It fails.
So the amendment fails. Okay. Okay. So now there are no further amendments to this bill. Further discussion. Senator West.
have one that relates to my discussion the other day about disabled kids applying to private schools that don't have the ability to educate disabled kids. And I admit I have not had it drafted, but I can read what I have written, which I can either, staff can put into amendment or I could. So it's on page 4 of 8. There's already a paragraph there that deals with disabled. It's at lines 8 through 11. As currently written, it says, with respect to discrimination on the basis of disability, a non-public pre-kindergarten program or a non-public school that provides a student with a reasonable accommodation under federal law. My problem is I don't know what a reasonable accommodation would be in the case of a school that simply doesn't have the resources to educate, say, dyslexic kids. So here's how I would rewrite that paragraph. With respect to discrimination on the basis of disability, a non-public pre-kindergarten program or non-public school that does not have a program of instruction, athletics, and other extracurricular activities that with reasonable accommodation can provide a full and equivalent educational experience for the person with the disability. I just wrote it, but I can email it. Heather, should I send it to you? Okay, and it's just Heather dot Marsh. Okay. Hope I spelled Marchione right. At senate.state.
Over there. MARCHIONE.
Gotcha. Okay.
Just a quick question, but for reasonable accommodations, what is there not enough case law that's out there that exists dealing with it at the federal level?
So that's what I went over at the end of, or during the last meeting. I can forward you what I've already forwarded to some members about the ADA and educational accommodation.
So we do. I mean, there is guidance. As to
So
what it means,
there
I
is
guess,
much
at the
case
point.
law.
Okay. Thank you.
Did you send that to me?
I think I had. I will do it right now in case. I'll send it to both of you. Weston. Yeah, so what I read at the end of the meeting last time was public accommodation is not required if a particular aid or service would result in either fundamental alteration of the services offered by the facility or if the accommodation would impose an undue burden. Under the U.S. Supreme Court's interpretation, Congress intended that undue burden and hardship must be determined on a case-by-case basis. So there's case law about what accommodation includes physical changes would mean about, and I stated like installing accessible doorknobs and hardware, grab bars in bathrooms, increasing maneuverability in bathrooms and wheelchairs, sinks and hand dryers within reach, handicap parking spaces, accessible water fountains, ramps, having curb cuts, sidewalks, and entrances that are accessible, installing elevators, widening door openings. And then non-physical building changes would be modification of applicant for testing, allowing students to tape record videotape lectures, modification of class schedules, extra time allotted between classes, note takers, interpreters, readers, specialized computer equipment, and special education.
No. I remember us going over this the other day, and I looked at some of the, there's an awful lot here requiring a private elementary school to install elevators and all this other stuff. It involves a lot of money. But what I was really thinking more of is the inability of the school to teach dyslexics, because you'd need specialized teachers with training in dyslexia for that. And there are certain schools that specialize in that sort of education, and other private schools simply can't do it. So where would that fit in, all this list of accommodations?
Again, it would be a case-by-case basis on whether or not that's considered reasonable. So I can't say blatant, like flat out, that dyslexia would.
So if we enact this bill as currently written, a family that applies on behalf of their daughter to go to a private school who has dyslexia.
I don't
who
know.
gets
You'd have to
turned-
see if the accommodations would be considered reasonable or not, which is a case-by-case basis.
Well, that's one point I'm making, that they would have a right to sue the school and take the school to court.
No, you're not suing the school. It's creating a mediation process under the bill.
Creating what?
It's a mediation process under the bill. You're not civilly suing.
So some independent persons could tell the school you have to hire teachers who are trained in dyslexia and accept this student and then teach them, right?
No, so under the bill creates a process by which an individual, a student or a parent of a student, can report the discrimination, and then it will be evaluated. And if the discrimination is found substantiated, they will issue or try to come to a mediation or agreement between the parties. If no agreement is found, then they will make a finding of whether or not it occurred. And if the school still refuses to make the accommodation, that's when funds may be withdrawn. It's not a civil right of action.
But the mediator is the state superintendent?
I believe so. Wait, double check. So it's reported originally to the county board, and then the county board shall submit a response to the state superintendent.
Right. I
And then the state
can't
superintendent is
accept
one who
a
mediates.
situation in which the state superintendent of schools is going to tell a private school, is going to, quote, mediate and tell a private school you have to hire a battery of teachers who can teach dyslexics if the the private school simply is not capable of teaching dyslexic students.
Superintendent coming in, telling them they have to hire a bunch of teachers for dyslexia and other things.
This allows the superintendent of the public schools to tell a private school that that the private school has to hire a battery of teachers who can teach dyslexia.
But would that be reasonable?
Does this provide that
No,
after the mediation?
Can you read this one more time again, the definition of reasonable, just to put it atop everyone's mind one more time?
It's not reached.
So I don't have like a set definition of what is and what is not reasonable because it's determined on a case-by-case basis. So an accommodation is not required if a particular aid or service would result in either fundamental alteration of the services offered by the facility or if the accommodation would impose an undue burden. And again, undue burden is determined on a case-by-case basis.
I don't know why we just simply can't enact language which would exempt private schools from having to, unless it's reasonable to have to make special efforts to educate disabled kids that the school's not capable of educating.
I guess I'm just struggling to realize, why do you feel that is not covered under the reasonable accommodation standard? I'm just trying to figure that out.
Well, I'm looking under.
You emailed some vignettes. You've emailed some vignettes, some examples of what that looks like. You've been emailed a broad definition. Just trying to, I don't understand. What you're struggling with here.
Well, in the event of a dispute, the determination of what's a reasonable accommodation goes to the state superintendent of schools, who's the head of the public school system. And I think it's reasonable for a private school to worry that the state superintendent of schools would not have the interest of the private school in mind in making the decision. So the superintendent could direct the private school to hire a battery of teachers who are capable of teaching dyslexia, and it should admit the dyslexic student, even though the school currently can't provide that student with an adequate education. And I don't think that would be right.
That was like the long list that I read about like the tape recorder just modified.
Just read that one more time.
Another time. Okay. So the chair asked me again to read what reasonable accommodations have been held. I guess this is more towards learning than building facilities.
I'm sorry, Heather, I'm having a hard time hearing you.
Sorry, I'll lean closer. So the chairman asked me to read again what some reasonable accommodations have already been found, which is modification of application and testing, allowing students to tape record or videotape lectures and classes, modification of class schedules, extra time allotted between classes, note takers, interpreters, readers, specialized computer equipment, special education.
Could I make a motion just to move the bill as is?
All right. Senator Sidner has made a motion.
Motion what, favorable?
Favorable for the bill.
Correct.
Favorable as amended. Senator West, are you still looking around? Or
Well, I can't vote for the bill as written. I've suggested what I think is some reasonable language which would protect private schools from having to make accommodations which are unreasonable in order to make accessible people with disabilities. So, I mean, we have a private school system, and the private schools typically are set up to educate students, particular groups of students, but students typically without special needs. The public school system has to educate everybody. The private school system does not have to educate everybody. And if we're going to require the private schools to be able to educate everybody, we're probably going to destroy the private school system because it simply can't do that at a reasonable expense.
Yeah, this is something similar. So the ADA, which is what this is referring to, does not require any accommodation that would fundamentally alter the nature or purpose of a school's programs. A requested accommodation may fundamentally alter a program in two ways. One, by altering an essential aspect of the program, or two, by causing a less significant change that has only peripheral impact on the program, but nevertheless gives the requesting individual an advantage over the other students. The ADA does not require a school to change its basic nature, character, or purpose to accommodate a student with a disability. So when I had referred to it's determined on the undue hardship is determined on a case-by-case basis, that was the case Davis, and in the Supreme Court ruled that a nursing school was not required to provide a deaf student with an individual supervisor whenever she attended to patients or to dispense with certain required courses for the student, or to train the student to perform some but not all of the tasks of a registered nurse is required to perform. The court reasoned that the nursing school was not required to dispense with essential requirements of effective oral communication by nursing students in order to accommodate the student.
Okay, here's what, could I make a suggestion? Could we hold this bill till tomorrow? We're having another voting session tomorrow. I will meet with Heather after our voting session today and get this information. I'll read it tonight. I'll go back over it all, and I'll come in tomorrow, and if I'm satisfied, I'll go ahead and vote for the bill without asking for any amendments.
All right, so the senators asked for a hold. This bill has been held once just for further amendment and clarification. So we'll do this. Senator Castle, you go ahead. And then,
I mean, look, this bill was introduced, as I understood it, to save time, because normally we simply do a very brief amendment on the budget language, take care of this. We've spent more time debating this bill than we ever did the budget language. I don't see this bill saving us any time, and I just think we'll make a motion for unfavorable. Let's just go back to the way we've always done it, that seemed nice and clean and neat, and this is not saving us any time at all. So I would just move unfavorable.
There's still a motion on the table right now for a favorable that we never dealt with.
It never got seconded.
Because it left it up, because I asked for a conversation first and we haven't got back to it. There's an interlude there. Senator made a request to hold it for one more day. We're going to hold it for one more day until tomorrow morning, once he gets clarification.
Well, can I just make, before we hold it, just make one thing really clear on where this bill is, because this is about the boost scholarships. And the way, the posture the bill's in now, irregardless of what Senator West does, eliminates the boost scholarships. That's the current posture based upon the rejection of the amendments. And so that folks know what the boost scholarship does, and those are the scholarships that provide poor inner city kids primarily with free tuition to attend high-quality religious schools of all denominations of their choices. And who are those? 934 of those are in Baltimore County. These are the number of kids. 723 of those are in Baltimore City. 310 of those are in Montgomery County. 230 of those are in Prince George's County. And those are just the big ones. Everybody, we have St. Mary's County has 46, Talbot 22, Washington 53. Everybody's got a bunch of these. Frederick's got 30. These are scholarships that we often find the young men and women that get these are able to overcome substantial hardships and really great hardships in their lives. And because they got a sudden opportunity to attend these very prestigious private schools, they go on to be medical doctors, scientists, moonlanders, all this stuff. So we're not going the right direction with this thing. I just don't know why we would possibly jeopardize those when we haven't jeopardized them in previous years. And all we've done to get this stuff by in previous years is insert a little amendment to the budget, capital budget language, which is the one that's in my last amendment, and everything goes through fine. And it's that little amendment. We don't require anything else. So that's why it's just, anyway, seems to me this ought to just go away. We were doing this. This was all working out well. A lot of nice young children, a lot of young children's lives were dramatically improved by what we've been doing stuff. And I don't think we should jeopardize that for any kind of technical reasons that we all may feel are so darn compelling. Thank you.
All right, so,
I just have a technical question.
sure. Well, hold on, we are going to hold this thing for one more day, but go
It's
ahead.
okay, I was just curious, I don't remember now, what is the amendment that we put on there already?
So if you look at Senator Cassidy's amendment, which is 3088079/1,
Yeah,
we took 1, 2. No, sorry, hold on. Yeah. Which basically conforms to the House.
Yeah, so right now, so the bill before you, if you just pull up the third reader at the House cross file, that's what JPR has in front of it right now.
So if you look at the back.
all right, I got it, so we have adopted amendment to make it the House third
Yeah,
reader.
we've conformed.
I got
We did
that.
not take this, the last piece, which is adopt the regulation.
We didn't take amendment 2, we took amendment 1.
Correct.
Okay.
1 and 2, yeah.
1 and 2 didn't take 3.
Yeah.
We
Took 1 and 2. not 3.
we took 1 and 2, we rejected 3. Yes, which was, okay, got it. No, we took amendment 1, we took amendment 2, it's 3, which is the one that we didn't take, correct? No, it's not right.
We took half of 2. We took 2 through, it says amendment number 2, and then it says on page 3 in line 6 about person and student, and then period. We took up to that period. Everything else we didn't take yet. We didn't
Okay.
reject it, we just didn't include it in the amendment that day. So
All
we
right.
have amendment 1 and the first 2 lines of amendment number 2. Nothing else has been adopted.
Okay,
Got it?
got it.
All right. Let's move on to Senate Bill 105.
Okay, so for Senate Bill 105, Peace Orders, Workplace Violence, Judicial Proceedings passed a similar bill last session. So this bill authorizes an employer to file a petition for a peace order that alleges the commission of certain acts against the petitioner's employee at the employee's workplace. The employer must notify the employee before filing the peace order. It extends most existing statutory provisions relating to the filing, issuance, modification of peace orders to peace orders filed by employers on this basis. An employer is immune from any civil liability that may result from the failure of the employer to file a petition for a peace order on behalf of the employee. An employer may not retaliate against an employee who does not provide information for or testify at a peace order proceeding. So the one amendment in your packet, which is 238372, so this is based off of the proposed amendment submitted by MAJ during the bill hearing. So there are two parts to the amendment. One, it specifies that the bill may not be interpreted to create or impose a duty on an employer to file a petition on behalf of an employee. And two, it removes an immunity the bill created for employers. This provision would have made employers immune from any civil liability that may result from the failure of the employer to file a petition on the behalf of an employee. So the rationale is that the legal duty to act may arise in other ways than this statute, for example, by contract, in customs and practice over time, by granting immunity as opposed to limiting the imposition of a new legal duty. Senate Bill 105 precludes the possibility that such an enforceable legal duty could ever arise by contract or otherwise.
All right, Senator Sinor, your bill, but
Packet, I was not aware of that amendment. Obviously, I like the bill in the form that it came in, but see if I can find it. I'm assuming Ms. Pop sent it? Yes. Okay.
I hate to speak on behalf of MHA's amendment, but, I mean, basically what they were saying, as I understand it, is they don't have any problem with the bill as it is, other than that their position is that an employer doesn't have any obligation to submit one of these. But let's say, take an example where the employer says, yes, Sue, I'm going to file that, we'll take care of that, and then they don't do it, then there could be some liability, because then Sue thinks it was filed, it didn't get filed, and then Sue gets shot. And so that's their position. So they don't want to create a duty, but they don't want to say that if you misled her to believe she was going to get your assistance, and then you basically hung her out to dry. Right?
let's give the sponsor of the bill a second to read it, but then we can take action on the amendment. And Charles, if you go into you can see their testimony. It lays it out pretty nicely. If you go into your laptop, into the bill file.
pass? Would this align with what the House did?
Let me check to see what posture it's in. So the House did not have any amendments to their bill.
That's
They
what I
passed it
thought.
clean.
That's what I was saying. I mean, I think that the argument is that this is something that our employers were looking for, and certainly in providing this ability to obtain a protective order, they weren't seeking to be taking on any extra civil liability and being able to file these peace orders. So, I mean, my argument would be just to resist and to continue following what the House did.
This seems like a good amendment, and quite frankly, it's shocking it's coming from the Association for Justice. It's providing civil protection from employees. So this is not typically what MAJ are employers. This is not typically their realm, but I mean, all I'm reading is does not impose a legal duty upon employers to do this. That's their amendment, correct?
Well, that's part of
Oh.
the part they're really,
Wait a
and this
second.
is why they honed in on this like a missile, was because of the immunities. And so if you go on page 4 of 16, like line 30 through 32, they're,
Oh, I see. The proposed
I think they're
amendment
right.
eliminates an overly broad immunity
Yeah.
provision with language that does nothing more or less than what the bill's intended. So they're like,
It
okay,
doesn't-
right now it does not impose a legal duty upon employers to do so.
It's a
And they want
may.
to change it to
yeah.
what? What is the language? I'm trying to look in their amendment.
4.
The employer is protected from civil suit. What they're doing is striking out that immunity with this amendment.
I guess it's because it's an option for the employer to file this.
Correct.
Okay.
Right.
So there's no duty to do it.
Correct.
And so there's really no exposure to civil liability if they don't do it. But by making them immune, you're kind of it's an unnecessary thing. It's not necessary, and you could open yourself up to other unforeseen problems by just granting blanket immunity. So I don't think it really affects, it doesn't hurt this bill. But, so I'm going to offer the amendment.
So it does, though, open the possibility, for suits, because you're not expressly precluding immunity. It opens up the employer to suits for not taking action, no?
No, because there's no duty to act. There's no legal duty to act. It's all.
So why do they want this gone?
Because it's unnecessary, and if you have a blanket immunity for something, I just think that's dangerous. But go ahead.
Yeah, the example that they gave was, I have no duty to act. I'm your employer. I have no duty to act. But then I say, listen, I'll file that for you. Don't worry about it. And then I don't do anything. And you thinking I filed, you wait a week and the protective order never came. In the meantime, your ex has attacked you and knifed you viciously, and you're like, well, I thought you were going to file it. That's their position. That if I could have just said, hey, it's your problem.
Right.
Not my problem. It's your personal problem. I had a right to do that. I have no legal obligation to do that. But if I say I'll do it, then I could be liable for it. That's the example they gave, which seems to make sense.
Yeah, okay, thank you.
Oh, the other point that MAJ raised in support of their amendment is that a legal duty to act may arise in other ways other than this statute. So you could contract to say that we will file peace order a peace order on your behalf. But if you have an immunity in the bill, you can never sue, even though you did have a duty under the contract to file it. So the way this amendment would work is just saying that this specific bill does not create any duty on an employer, and they're not immune from civil suits. But if you don't have a duty, then you could be responsible in other ways, such as a contract.
Clarify, so they want to add the word does not impose a duty? All right, I see it. So on the bottom of their testimony, well, yeah, that's fine.
But I don't think the bill prescribes it's a duty, right?
No, but it provides an immunity, is what they're saying, a blanket immunity, which SB 105 precludes forever the possibility that such an enforceable legal action could arise by contract or others. They don't want a blanket forever immunity. They just want to say it doesn't impose a duty. So they don't have to do it, but they don't want the reverse of that to say you forever have a blanket immunity on it. They're saying their amendment, I believe, Mr. Chair, you correct me if I'm wrong, it would protect from immunity too. It just wouldn't be as legally
It would protect the employer?
overly broad.
And that's what they're saying. Look, a legal duty to act may arise in ways other than by the statute, by contract. This is like exactly what counsel just says. As customs and practice change over time, by granting immunity as opposed to limiting the imposition of new legal duty, SB 105 now, as drafted, precludes forever the possibility that such an enforceable legal duty could ever arise by contract or otherwise. So you've completely blanketed out any exposure to liability by granting this immunity.
So they believe
Forever and ever.
So they believe forever. I don't know if anything's forever, but the maker of the bill, can you? How do you see this? And did MHA speak to you regarding this amendment?
Them mentioning it during the testimony. What I will say is last year this committee voted this bill out. I think it was a 10-1 vote with this immunity and the same language in place. So I mean, again, it's obviously it's the committee's will, it's the committee's bill, but I would resist it.
MHA.
Chair, it took me a while to come around to this bill. I'm influenced by the fact that we passed it out last year and that now Senator Sidnor is passionately advocating for it. In all honesty, though, I think that the amendment makes the bill better. I think that it is dangerous to have a blanket immunity, and what we want is to enable an employer, I think, to be able to file this third-party motion on behalf, but we don't want to impose an obligation or a duty to the employer, I think. So, I don't want to go against the will of the bill sponsor, but I actually do kind of believe this amendment improves the bill. So can you?
Yeah, I guess where I'm hung up on it, and besides, obviously deferring to the maker of the bill is, so it's, if I'm the employer, I'm not like obligated to do this, but this will enable me to do that, and I think I'm covered if I do that. But there's no obligation on my part to, take your circumstance and say, hey, look, I will lift this from you, and So I'm trying to actually see where. So MHA actually is in favor of the bill in written testimony and probably oral. I'm not sure if that or not on the original bill, and then now they have an amendment. I'm not sure if it's. I'm trying
to. A new language on bill page 3. I guess it's line 2. I think what you're arguing is right, because we are not trying to impose a new duty upon the employer. You know what? let's go ahead and roll it and just see what comes. Okay? Vote your conscience. Don't worry about me.
No, I'm
I'm voting for the
I'll
amendment.
explain.
All right, we do roll call. The amendment.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Can you pass?
Senator Jackson.
Yes, and I don't know if we typically explain amendment votes, but what I'll say is, look, having been an employer of hundreds and hundreds of folks, things happen, and I think if someone wants to help someone out, the fact that I'm trying to lift the burden from you, but my family's not really wanting me to bring that burden home should something go wrong, if something shouldn't go right, and I actually think that this does not hurt the bill. That's just me. I vote yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Senator Sidnor.
I'm going to stick with my committee, okay.
Chairman Smith.
Yes. Kumbaya.
Passes.
Are there any other amendments? No. So everyone understands what the bill does? All right, motions for favorable
With amendment.
with amendment. It's been seconded. Is everyone okay, or do you want to roll it? All right, everyone's good. Everyone's fine, okay. So, all right, we'll now move on to Senate Bill 144.
Hey, so this bill establishes standards relating to the installation and use of electronic vehicle recharging equipment in condos and HOAs. The bill establishes a grant program with the Maryland Energy Administration, MEA, and authorizes a condo or HOA to apply for a grant to facilitate the electrical upgrade of a parking structure. And then MEA must adopt regulations to implement the program. However, I should have begun with this. There is an amendment in your packet. So the bill as amended strikes the grant program and the relating language. So it only establishes the standards relating to the installation and use of electronic vehicle recharging equipment in a condo or HOA.
Sponsor amendment, right?
Yes, that is the sponsor's amendment.
What does the amendment do again?
So it strikes the provision in the bill authorizing the governing body of a condo or HOA to apply for a certain grant, and it strikes the creation of the grant.
Oh, so the bill was initially creating a separate grant?
Yeah, it's because it's kind of duplicative by current law. Like, there are
Oh,
other
okay.
ways to get the grant.
What was the grant for?
To,
I guess it doesn't matter because it's stricken for
yeah.
All right. Is that, so good, yeah, good.
Because, so if I got a condo unit and the condo unit says, look, we don't want to do this. We're going to set aside 6 stations or whatever for people to use. And then I say, hey, you know what? I don't like sharing. I want to have my own. Then this would say, then now they got their 6 that are for general use, but then they got to set one aside for me. I mean, that would happen under this, right?
Can you repeat the question?
Sure. I could just imagine that some condo units, electric charged vehicles are becoming more and more popular. So I could envision that a condo unit would want to say, rather than deeding these things out, we're going to set, we have 12 condo units, we're going to set aside 6 spaces for electric vehicle charging, and we're going to put signs on them, electric vehicle only. But then I have money and I don't want to share anything, so then I would be able to say, okay, look, I want my own, and I want a 7th one. Is there anything in here that says, no, that's not the scheme that this condo association wanted? They wanted this shared scheme, and that's why they set these
So if you look on page 3 of the bill, subsection D, this is
subsection
when
D? I'm sorry.
D as in
Okay.
dog.
Gotcha.
The governing body shall approve the installation of electronic vehicle recharging equipment in a unit owner's deed parking space or parking space that is specifically designated for use by a particular owner if, and then it goes through when they would be required to
Is not impossible.
pass it.
So strange, like word.
So it's D1.
That's awesome. I've never seen that before. Should we strike that?
Yeah, we would say it's
It's not
possible.
impossible.
Yeah, not impossible.
So, yeah, I mean, if you
We should
wanted
probably strike that.
to change it,
Yeah.
maybe line 16 is not.
I mean, wouldn't you say it's reasonably, not impossible, it seems to me you would say it's reasonably possible, and, I mean, otherwise,
that reasonably
this is
possible?
like to dream the,
Yeah.
wait a second, you could have climbed that tree and put it over there. And that's an or, so I'm not sure how you would want to do that, because or and is reasonably, or if you would take to strike the or and have an and, it doesn't impede and it's reasonably possible to do so or something?
Yeah, because it would go from negative to positive. Yeah.
I think, language like that would satisfy my concerns, as long as they could say, look, this doesn't, you messed up the scheme here, it's just not reasonable to do that, right? That would fix my concern.
All right, so the only addition to this amendment then is you're striking is not impossible. You're changing the or to an and you're adding reasonably possible. We can just incorporate into the same amendment.
Yeah.
Okay. Is everyone okay with adopting this amendment? It's a sponsor amendment. You understand the change we just made? Okay, great. Further discussion on the bill. So now just give us a high-level recap again what the bill does. Heather.
So the bill as amended, it establishes standards relating to the installation and use of electronic vehicle recharging equipment in condos and HOAs. So with the oral amendment, so we struck the grant language, and with Senator Cassidy's oral amendment, the governing body shall approve the installation of an electronic vehicle recharging equipment in a unit owner's deed parking space or a parking space that is specifically designated for use by a particular owner if the installation does not unreasonably impede the normal use of an area outside the unit owner's parking space and it is reasonably possible.
They can't prevent you from doing it.
Amendment. I remember back to the hearing, and I thought that was part of the problem with where the way the situation is now, is that, having a cord, that there were some people who were upset that having a cord go across the sidewalk, I guess that goes to the question of what's reasonable and unreasonable in terms of impeding. So I guess I'm not, by inserting that language, I'm not sure we're helping to clarify the situation at all.
The language says it's not impossible.
Yeah, we just struck that.
Unfair standard to the.
And it's already up above, it says, does not unreasonably impede, that's already in the bill. Does not reasonably impede the normal use of an area outside the unit owner's parking
So
space.
what are we, I guess, by adding that language, what are we doing?
Instead of saying not, it just is not impossible, you just say reasonably possible to do so, to accomplish all of the aforementioned. To just, and,
Did we already adopt this? Because if we did, I'll stop, but,
yeah, we did.
okay, I'll stop.
All right, is everyone okay with that? Second? Favorable with amendment? Is everyone good? All right, excellent. Okay, so. So I know we have a number of amendments to discuss on Senate Bill 154, but there are also just a couple conversations that I need to tie up on in terms of considering those as the amendments, but then also just allocation of funds that are collected, and so I haven't had a chance to tie up those conversations yet. So I'm going to ask to hold until I have an opportunity to just touch base with all the parties, and then we can consider the stack of amendments, but then also I'll have information about how much money things are going to cost for certain entities that are operating and where the money should go, and just so we have a clearer understanding of what we're doing. And the same thing will go with kind of the corresponding bill here, which is the Attorney General's bill. And we'll probably hold both of those because they move together. And I just want to make sure we have more information in terms of, I know the fee's going to go up, but what are we doing? You know, and what are the impacts? What are the fiscal impacts of certain numbers? So, sure, go ahead. Absolutely.
Because I'd hate to hold it and then I come back with a question and you got to hold it because you don't have the answer to that question. So just sort of a conceptual question. I just want to get clarification is I'm looking on the, I guess this is the reprint link or the bill reprint, whatever. It's page 5, line 23. This talks about that organizations shall provide legal representation unless, and then one of the unlesses is the designated organization lacks the capacity at the time to legally represent the covered individual. And I don't know what capacity, I know, I do a lot of guardianship cases. I know what capacity means in the terms of a guardianship case, your mental capacity, but I'm not sure what we mean in this bill. What is our intent to say lacks capacity? Does that mean they just don't have the funding to do it? They ran out of money? And if that's what we mean, we should say lacks the funding to do it or something.
So, thank you for the question. Originally, I think, yeah, they didn't have the money or the people power to do it, but at the amended version of the bill with my amendments took that out.
Oh, that language is gone?
Yes.
Would I miss that? I'm sorry. Okay.
Yeah, I'm happy to send you kind of the reprint of the latest version.
Okay. Yeah, I don't have that. All right. Thank you. I'd like to see that.
It should be, it's in the packet. Yeah.
It is?
Yeah.
Okay, here it is. It's 870?
Yes.
Okay. I'll look at it on my own. Thank you, Mr. Chairman.
Yeah.
Appreciate it.
Go down to, all right, we could just blow this, so just for folks, I know lots of people are paying attention to this one, but for Senate Bill 202, they're just, look, I think there's some questions that I'm going to go back and, there's some practitioners, some people in academia, people in advocacy organizations that I trust and have been relying on for their expertise to get some information just about how the parole board works, what the process looks like. So I want to make sure I just touch base with them one more time. I know that another member of the committee wants to do the same thing for, some amendments that they're considering. At this moment, I don't think the amendments are necessary, but if there's more information that comes out, we'll have a more informed debate and we'll talk about it. So we're going to hold it for one day. So when we come back, this will be the first bill we vote on tomorrow morning. I'm going to, Senator Cashley, and then I saw one other hand. Go ahead.
Tomorrow morning, the Rules Committee is voting on amending the rules. It would not include life without parole, but every other sentence that's beyond 25 years to provide a judicial process by which after 2/3 of the sentence is served, they would have a right to come back to the trial court to review their sentence. So sort of gives another, makes the trial court sort of a lasting parole board, I guess, really. This only applies for sentences of 25 years or more.
Would that be like a panel, a 3-judge panel or something? Like what would that look like?
It could be the trial judge, or in many
same-
cases,
the
it'll be
same
somebody- In most cases, no, not unless the guy
as I said.
sentenced you when he was a rookie on the bench. Almost certainly, it would be a judge from that bench. And
You-
then
do you have
it
the
wouldn't
proposal?
necessarily be a panel. I mean, certainly the judge, the chief judge of the court could say it was a panel if they wanted to, but it's not in the rule. So.
Got it. Like I said, got it. But this will be the first bill we take up tomorrow morning. But like I said, I don't think the amendments are necessary, but we'll dig in. I'm gonna talk to some folks. You're gonna talk to some folks. We'll come back.
So definitive on the amendment. There's a lot of, to be honest, with these bill hearings and advocates leave to be desired, that few people actually understand the parole board process. And there is certainly some complexity there that has been left out about how they actually vote. And the amendments, I think, that I have, I'm only responding because you said they're unnecessary. I actually think they're very necessary, and specifically on the of how the parole board votes. I do not think the public and a lot of these advocates and other people understand how they actually vote right now.
No, I think, and that's one thing too. One thing I'll have for the committee is just like some more information on how that process works. And frankly, I mean, even I learned more stuff talking to council this afternoon, so we'll have a more informed discussion on it tomorrow. But it'll be the first thing, so it'll be a good debate, good discussion. All right. Let's move on to Senate Bill 364.
Can you get me, Sandy?
Last bill, just so the members know, if you don't know, we actually have at least one senator who sits in our chamber who served on the parole board, Senator Patterson. In between the House and going to the council and back, so he actually sat there.
You know what? I didn't know that.
Yep, he actually did that when he ran for Senate from the House. He lost that race and he got placed on the parole board, and then he ran for county council before he came back here. So yeah, so she's got some action.
Yeah, I'll hit him up as soon as we wrap up here. All right. So Heather, go ahead.
Senate Bill 364. This bill only applies to a claim or suit arising in Baltimore City, and we do have a delegation letter. This bill prohibits a confidentiality or other non-disclosure provision in a settlement agreement or general release of liability between the parties to a claim asserting misconduct in the performance of duties by a law enforcement officer of a law enforcement agency of an institution of higher education. The bill applies prospectively.
You want to speak on it real quick, or the Baltimore City Senators?
Happy to roll it. Second.
All right.
Right?
Go ahead, Senator Castley.
This would also this would apply to University of Maryland and University of Baltimore, all those institutions, right? I'm sorry, they are already? Well, the Institution for Higher Education has the meaning stated in the education article.
Oh, Senator Castley?
Yes.
So the U.S. Court of Appeals of the Fourth Circuit determined that non-disparagement clauses amounted to a waiver of a claimant's First Amendment right that is unenforceable and void because the city's interest in enforcing the waiver are outweighed by the strong public interest firmly established in the First Amendment. However, the Court of Appeals rationale does not agree to a private institution such as Johns Hopkins University, since it's not a governmental entity. And then in addition to that, Baltimore City Code currently, after that Fourth Amendment case, Baltimore City Code prohibits settlement agreements between Baltimore City and claimants for claims involving police misconduct or unlawful discrimination from including non-disparagement clauses. that require a claimant to waive the claimant's rights to make specified statements regarding the claim.
Right, I understand, I mean, Baltimore City can do anything they want on Baltimore City, but does the law currently prohibit non-disclosure agreements for University of Maryland? A public institution?
It would be it's a public institution, it's a government entity.
I can't hear you, I'm sorry, I really,
The U.S. Court of Appeals Fourth Circuit decision would
they said you
control.
cannot do it?
Yeah, they said it because it amounted to a waiver of a claimant's First Amendment rights.
Okay,
So it
so
prohibits
the
those.
Court of Appeals has said you can't restrict non-disclosure, you can't prohibit non-disclosure agreements. Is that what you're saying?
No, sorry. It's saying that non-disparagement clauses are unenforceable.
The Court of Appeals said that
Yes.
in both and that was in the case involving public university or municipality or?
My notes simply refer to the city.
Is it correct, Heather, that I thought what you've read is the Fourth Circuit's opinion already applies to public entities? The bill specifically, but it excluded private institution that we're aware of. The only private institution that might potentially one day have a police department would be Hopkins. So really, it's probably directed more there or any other private institution that chooses to get a police department.
Right, so, but the institutions of higher education, which has the meaning stated in the Education Article, Section 10-101, I assume that includes any institution of higher learning, whether it's public or private? Is that how this bill works then?
And I don't want to speak for the Senator Cassidy, but I guess, or I think what I'm hearing is the bill only for Baltimore Police Department? Or does it include any police agency in the city, which would include the universities? It would include any police agencies in the city.
Overall scheme in the statute, but this doesn't, on the face of it, it doesn't say anything about this is a statewide bill unless something in this section 5644 of the court's article pertains only to Baltimore City.
On the bill, lines 9 and 10, this section only applies to a claim or suit arising in Baltimore City.
I'm sorry, this is on where are we?
So this is on page 2 of the bill, lines 9 and 10. This section only applies to a claim or suit arising in Baltimore City.
But the entity could be like the University of Maryland, which is statewide. If it's the entity is operating, like you have like the dental school or law school.
Yeah, they would have to be operating within Baltimore City.
So the entities that are not Baltimore City centric still get rubbed in.
Yeah, I see it there, but then this would,
I guess it has to happen.
Has to happen
In the city.
Yeah.
okay, and you're saying that the only one that's excluded, we already prohibit, so this would be all higher education institutions, and you're saying that the state schools are already covered by this, or already cannot use non-disparagement clauses?
So, according to the fiscal note, Baltimore City Code prohibits settlement agreements between Baltimore City and claimants for claims involving police misconduct or unlawful discrimination, including non-disparagement clauses. The Fourth Circuit, that is case law. So that's not covered by the code. That would apply to like larger within the Fourth Circuit versus the city. It says,
Small bills, you think it is,
Yeah, the statutory provisions directly, there are no statutory provisions directly applicable to the bill, except a law enforcement officer is an individual who, in an official capacity, is authorized by law to make arrests in a manner of one of a list of specified law enforcement agencies, including a police force of the University System of Maryland, Morgan State University, and Baltimore City Community College, and the Police Department of Johns Hopkins University.
They don't. They have enabling legislation to create one.
So
But they will,
so
though.
if I understand this correctly, then you've got University of Maryland College Park, you could have non-disparagement clauses, but University of Maryland in Baltimore City, you could not have non-disparagement clauses for the same police department, for the same police force, right?
Except for as long as the incident arose within the city limits.
Within the
then-
city limits,
Yeah.
right. Well, I'm not sure how College Park would arise in the city limits, but that's how I read this, is that we would have one standard for non-disparagement of university campus police in Baltimore City, and another one for university campus police in College Park, University of Maryland Eastern Shore, University of Maryland, wherever, I mean, all the many campuses, they're all different standards.
I mean, at least two, right? At least one in Baltimore City and the rest of the
What's
state.
that?
I don't know what the rest of the state has done, but I don't know what these other jurisdictions have done, but at least two. You'd have Baltimore City and the rest of the state. At least. At the very least.
I'm sorry, at least what?
Two different policies for non-disparagement agreements or NDAs, right? I mean, you'd have whatever happens in Baltimore City, and then I don't know what the other, like Eastern Shore, what their policy. I have no idea.
Right.
Wouldn't it depend on how this school is classified? Because if it's a public institution, it's bound by the Fourth Circuit's decision, because the constitutional protections would apply, which would prohibit the non-disparagement. But if it's a private institution, constitutional protection does not apply. So I think you'd have to look at the nature of the school first. Is it public or private?
So in a public institution, we can't say that they can't have a non-disparagement, is what you're saying?
So if it's a public institution, I think the U.S. Court of Appeals for the Fourth Circuit, their determination that prohibits non-disparagement clauses would apply, because that it impedes the First Amendment rights of the individual.
Okay, so the Fourth Circuit has already said that you cannot use non-disparagement clauses in a public institution, right?
That case referred to the city, so it wasn't a public institution of like a school, but it was the I think it was Baltimore
government.
City.
It said the government can't require a non-disclosure, which would mean that would apply then to all government, which would include the University of Maryland in all of its various permutations.
That's my.
And so the
I think
intent of this bill is to close the gap on the private, because
Johns
they're saying
Hopkins.
that would
A
not
private school, because they have they're acting in a police manner,
capacity. Okay,
but
thank
they're
you.
not bound by the
All right,
Constitution.
thank you.
All right, so this only applies to private institutions in the city, and are we setting up where these private institutions in the city are going to have a completely different civil standard than everywhere else? I mean, it just seems odd to me that we're going to have this, I don't know, I've got two attorneys that do a lot of civil law. Is that correct, to have one civil standard in the city and another civil standard everywhere else?
So I think in order for a conflict under this bill to arise, you would need to have a law enforcement officer of a law enforcement agency of an institution of higher education outside of Baltimore City. So because this bill,
not that part, but I'm saying that how, like, we're passing a law dealing with these disclosure agreements, everything just for the city, and it strikes me as odd that we're going to deal with civil law in one way in the city, and then it's treated completely separately in the rest of the state.
I don't. Is there a private institution?
So Hopkins is the largest employer in Maryland. They have campuses all across the state. So if they have a campus in
I
Montgomery,
see what he's saying.
yeah.
Okay.
So they have a campus in Montgomery County, and they have campus police there. They're now under a different policy or law. If we pass this, then
Yes,
yeah.
I see what you're saying now. Then yes.
However, under that example, outside of, I believe it's the Crofton Police Department and Ocean Pines, Hopkins is the only private institution or private entity that has police powers.
Passed
Yeah, which,
only applied to
they haven't
Hopkins and
created it
Baltimore
yet,
City.
but yeah.
It didn't apply to Hopkins campuses across the state.
No, I got you.
Nope. I just have a quick question. So I heard people referring to a non-disparagement agreement. Is that in the amendment? Because in the bill, it only refers to a non-disclosure,
It's just an idea. That's
but not a non-disparagement.
correct.
Okay.
Was the Fourth Circuit a non-disparagement or non-disclosure?
Yes, the language was different within bill, and so the Fourth Circuit is a non-disparagement clause.
Just an NDA of sorts.
Yeah, and then Baltimore City Code refers to a non-disparagement clause. And this bill prohibits a confidentiality or other non-disclosure provision.
That's much broader, though.
The bill is broader.
You want to align it, make it the language match?
Well, NDA is a lot broader than a non-disparagement agreement. A lot broader, but. Defer to the city senators. What do you all? What was the discussion like in delegation?
I don't remember. Go ahead.
Honestly, there was not much. There was more discussion here than there was in delegation.
Surprise. I mean, not saying anything.
I mean, to be honest with you, my opinion is the committee's will. It's a city bill. I think that the city delegation voted it should pass. But if there's more comfort actually aligning the language to match what the Fourth Circuit said and what the Baltimore City Code says, then I think that we should probably do that. Well, on the other hand, my personal opinion is make it as broad as possible.
Are the city senators okay with that amendment? Okay. So we're just making a match with the Fourth Circuit, so it's non-disparagement, not just the NDA.
City institutions would have. So I think that makes sense, even though we might want to clamp down a little bit more, a little harder on this private institution.
What do you want to do? So we adopted the amendment. Everyone's okay with that. What do you all want to do? Further discussion on the bill, or do you all want to make a motion?
Second.
Seconded. Is everyone okay? All right. The bill passes as amended with amendment. All right, Senate Bill. Jamie, I think you're up. Senate Bill 471.
Senate Bill 471 extends the task force to study crime classification and penalties by 1 year to sunset June 30th, 2022. A final reporting deadline is set for the end of this year, December 31st, 2021.
Mr. Chairman, I have a question for the member of our committee that's on there. My question would be, what's the problem? Why haven't you all gotten this done yet?
I'm not the chair. I'm not the chairman. All right, is everyone okay with that? Everyone's good? Favorable. actually, Heather, we can start off with this. So Senate Bill 504, still working out with some of the, there's some folks, industry folks, that we've been working out with amendments, so we're going back and forth. I'm almost there with this, but I do want to adopt one amendment, which I think, Senator Castley, you had brought up about just workplace and not wanting to be under the influence, and kind of the inability to test. So I wanted to offer this amendment, see what the committee thought, and then I'll continue my work with the industry folks, and I'll bring it back either tomorrow or next week. June. Yes, yeah. No, it's just mine. Yeah, right. We have enough vehicles. Yes. Yeah, just talk about that.
Yeah, so Senator Smith was referring to the changes made on page 3 of the reprint. So if you see subsection G, so this specifies that the bill does not prevent an employer from adopting policies and procedures that prohibit an employee from 1, performing the employee's duties while impaired by medical cannabis, or 2, using or possessing cannabis in the employer's workplace while performing the employee's job duties or while on call, or 3, holding a position directly affecting public safety if the employer can demonstrate that an employee's inability or impaired ability to perform essential functions will result in a direct threat to public safety. That language was based on language from the EEOC about whether an employer has the ability to ask whether an employer may ask an employee the employee's medications, and whether that's discrimination. And then 2, an employer may discipline or terminate an employment of an employee for violating a policy procedure adopted under G1.
Public safety. So we have a job site. We're all fellow employees. Just outside the job site is the public. If I'm a threat to, I'm the heavy crane operator that lifts a 15,000-ton thing and swings it through the job site, I'm not going to affect the public, but my fellow workers are all working beneath me, and if I screw up, I'll squash them like pancakes. So is that public, or should we say a fellow employee, another employee, or the public? I'm not. To me, public safety sounds like it's the people offside the job site. So if I swing and it goes outside the job site and hurts somebody.
So I think Heather has the language, but the EO also provides like some guidance and some examples of kind of professions that are covered in situations. So I don't have it. I don't have the email up, but could you read it? Just.
This answer is in response to the question about whether an employer may ask all employees what prescriptions, medications they are taking. So generally, no. However, in limited circumstances, certain employers may be able to demonstrate that it is job-related and consistent with business necessity to require employees in positions affecting public safety to report when they are taking medications that may affect their ability to perform essential functions. Under these limited circumstances, an employer must be able to demonstrate that an employee's inability or impaired ability to perform essential functions will result in a direct threat. For example, a police department could require an armed officer to report when they are taking medications that may affect their ability to use a firearm or to perform other essential functions of the job. Similarly, an airline could require its pilots to report when they are taking medications that may impair their ability to fly. A fire department, however, could not require fire department employees who perform only administrative duties to report their use of medications because it is unlikely that it could show that these employees would pose a direct threat as a result of their inability or an impaired ability to perform their essential job functions.
It's 70 miles an hour through downtown Los Angeles? Oh, Okay. So and that doesn't really answer the question, whether we should have it's a threat to the public or to fellow employees or to other employees. That hasn't been answered yet in what you just gave. In each of the examples you gave, it was clearly public. The police officer is going to go out with his gun, he's going to go into the public, and if he's high, he may shoot a member of the public. I'm specifically asking, in those cases where I don't work around the public, where I'm working inside of a factory and the nearest public is 200 meters away, there's like remote chance that I could ever impact the public, but I have a lot of fellow employees who I could kill. But they're not, I wouldn't normally think of them as the public. And then I would think that this would have to be amended to say a threat to the public safety, or to fellow or other employees on the job site, or other employees, fellow employees, something like that.
I see what you're saying. I don't think making it more specific would alter the purpose of the amendment. However, I do think it would be covered under public safety, because so it's, if you are in a factory, the other individuals who are working at that job are members of the public, and they would be directly potentially harmed.
Normally you think of public safety, I mean, you have the police are all together working, and they don't normally think of their fellow officers as the public. The public is people outside of them. They are the police. The same thing with on a job site, where you say, here we all work, we're all together, and you say, there's the public area. And back here, you can do what you want. But when you go out to the public area, where you're interacting with the public, meaning the constituents, the people we're trying to influence, those are the public. So I don't think on a job site that public would refer to fellow employees. That's my concern. That just because, yeah, they're civilians, they're people, but that doesn't make them, that's not the public. I mean, you would say public, you go to any government building, you say, here's the public entrance, and there's the employee entrance. Any big company, I mean, you go to visit Clorox or GM or anybody, you're going to have the employee entrance and the public entrance. Public entrance just gets you to the front desk, and now what do you want to do here? Employee entrance goes in the side. So to say this is for public safety, I don't think gives us what we need. We should say public safety or the safety of fellow employees.
Because my one concern is when you start adding too many adjectives in front of something, it's like, is there something that's being left out that you intend to cover? So because it says public safety and you're not saying public and employees, is there something that would inadvertently be left out? So could you just say safety?
That's good, Bob. Yeah, I have a really hard time hearing you. I'm sorry. I never hear what you're saying. So.
Sorry.
If you want to broaden it, that's fine.
My concern is that if we start adding too many adjectives, public safety, employee safety, we might accidentally leave something out.
Okay.
So if we just say a threat to safety,
That's fine with me,
that
too.
way we're not leaving anyone
Leaving anybody
out.
I like, that's better.
That'd be okay?
That's the best, yes. Threat to safety. Yes.
Safety.
Safety. Just straight up safety. Good.
Okay.
It doesn't hurt. I don't fundamentally changes, but that's good. We'll go out and then. Senator Bailey.
A question, not so much on the public safety end, but on the safety end. Like, so for instance, I have a DOT card. So when I go in for my DOT physical, I am tested for marijuana every time, right? It's federal law. If I pop, then I can't have my DOT card. There's nothing that does that for opioids, right? I could have prescription, medical doctor prescribe opioids. I could still drive tractor trailers, no problem, no issue, whether I had it or not. But if I was under medical marijuana, I couldn't. I wanted to just see if we were setting up a different standard, different that exists for what currently exists under current law for opioids or any other treatment for an injury is different than that if you were receiving medical marijuana.
No, I think we're trying to bring them on parity, and I think what you said actually bolsters like a lot of the reason for the bill, because you can't test for those opioids, although it's still, you can't do it. You can't be under the influence when you're operating heavy machinery, or the CDL, that's what the CDL, right? CDL license. That's what yes. You can't. If you're involved with any of that, you can't be under the influence. And I think bringing that up with, I think the bill covers that for medical marijuana, but also just says, but your employer can also not discriminate against you based on the fact that you have those opioids and you need them for pain management or whatever else, because it's medicine.
Not lose your CDL. But if you have a medical marijuana card, you lose your CDL.
So that's right, only because it's one is a Schedule 1, right? You can't. That's already covered under this bill. You're not going to be able to do that. You're not going to be able to have a CDL. That's what they wanted specifically spelled out, which is those industries, those government agencies, but it's already covered.
I understand that you can't operate, but what I'm saying is just the fact that you have a medical marijuana card for medical treatment, you lose your CDL.
That's correct.
Okay.
And that
I just find it ironic that you could be under a doctor's care and be prescribed opioids.
Yeah.
And you could still have a CDL.
So do I, actually, but hey.
Right.
Yeah, we're on the same page on that one. But this bill doesn't touch that, and even for medical marijuana or cannabis. Okay, so we can adopt that, and we'll come back to it. I'm working with the industry folks. And so, Bob, I hope that assuages some of your concerns, at least on that end. And then, okay. You just got to team up with more. We got to get you down to Coleman Park more often, so you hang out with your new buddies. Yeah, there you go. All right, let's go to Senate Bill 505.
Senate Bill 505 establishes that a violation of the state's prohibition on first-degree child abuse, that it is a violation of the state's prohibition on first-degree child abuse to engage in a continuing course of conduct that includes 3 or more acts of second-degree child abuse. Violators are subject to the existing penalties for first-degree child abuse. There is a provision in current law that relates to a continuing course of sexual abuse of a child. That's under Section 3-315 of the criminal law article. This is distinguishable from that section, but I would note that the wording of that prohibition is slightly different than this one. That prohibition applies to 3 or more acts over a period of 90 days or more. So there's within the text of this, there isn't a specific time frame that would happen in to qualify as first-degree child abuse.
Mr. Chair.
No, I just think this closes a loophole, and there was nobody who testified in opposition. There were a number of people who are prosecutors and child advocates who thought that they have a number of real life cases where they've been unable to make this more serious charge of child abuse, and this would close that loophole.
Mr. Chair, so I actually had a concern about it. I did look, and I didn't notice there was any opposition testimony there. I didn't see anything from the public defender or anybody in opposition. But it's already been categorized whether it's a first degree or a second degree. And oftentimes, if it happens a subsequent time, we will then allow for an enhanced penalty. But I feel that rather than allowing for an enhanced penalty, because this is something that's occurred more than once, brought up, is that normally when there's a course of conduct, like harassment course of conduct or whatever, or sexual offense, it's usually within a time frame to be a course of conduct. It can't just be an open-ended course of conduct. And so I think that if this committee has the will to pass the bill, I do think that there should be some time constraints placed on the course of conduct. But I also would like further guidance on why we would not just have an enhanced penalty for a subsequent offender, as we do in most areas, as opposed to changing the character of the crime from a misdemeanor to a felony, or second degree to a felony.
I mean, if it's the will of the committee to put on a time limit to make it more parallel to the repeated sexual abuse, that's certainly something we could talk about. But I mean, the examples that doctors and that the prosecutors gave in the testimony was pretty serious, and because they were judged on independent acts, they were not able to. I'm trying to respond to your question. I'm trying to respond to the things that you raised. If it's the will of this body to put in the time frame, okay, to make it more parallel to the sexual abuse, but these are pretty serious crimes, and what I think the evidence that was presented at the hearing was that they warrant raising it from a misdemeanor to a felony. I mean, we're talking, this is child abuse, and because they don't have, because they don't have the ability to make it a felony, they had to look at the cases individually rather than being able to put them together to demonstrate a pattern. So I appreciate what you're saying about an increased penalty, but I think it warrants bumping it up to a felony.
So it's not just about an increase, or maybe addressed it. What I'm saying is that we decide these are the elements of a second degree offense. These are the elements of a first degree offense. My level of discomfort is with the idea of saying, just because this second degree offense happened more than one time, we're going to change it and call it now a first degree offense. I understand course of conduct, and if we want to go that way, we really should put a time period that the course of conduct occurs. But I lean more toward just saying, hey, this has happened more than, if it's outside of that time frame, then it should be, it's happened more than once, we would entertain an enhanced penalty on this fact that it's occurred more than one time.
I think if I would rather go in putting in the time period, because I think it demonstrates a higher level of consistency in child abuse if you're talking about multiple multiple incidents.
I think actually, Jamie, I was looking at the I do have a comment. Actually, I like this bill, and I would be worried about adding that. I'd be worried about adding the, 90 days for a sex offender? Because I'm worried about it, because the testimony that came in was pretty good. That these adults that are doing that are abusing these children. They're doing it multiple times. And I worry that if they do it 3 times and it's 100 days, that you catch them, they wouldn't get the penalty. But if you explain what we did for sex offenders, I'm trying to figure that out right now. It's 90 days. 90-day period, I got it. Repeated sexual abuse over a 90-day period is considered a continuing course of conduct.
But it's actually, so it's interesting, Senator. I was just going back and looking at it, and in that section, so that's section 3-315, the way that it's phrased is actually over a period of 90 days or more. So actually, I think that the clock, it doesn't actually become a violation under that until if it happens in less than 90 days.
Okay, so that makes, all right, that's interesting. So if it happens within 90 days 3 times, they just charge us 3 different instances. But if you do it for 91 days, they charge it 3 times and a course of conduct?
That seems to be the reading of that.
That's odd. Yeah, go ahead.
Yes, I mean, I know a lot of times we put in the law that if you do a certain act within a certain proximity to another time, that we're going to nail you for sort of repeating this, and that, hey, but if it's 3 years later or 5 years later, we're going to break that chain and you get to start back over. But I don't see how that logic applies in this particular crime, because to say to a child, I mean, they're living with this trauma, and it almost gets worse as time goes on, because she was 5, and then she dreaded it, and then it happened again when she was 10, and she never really, and then it happened again when she was 15. Each stage of her childhood was destroyed by this. She wasn't like 10 looking back on a abuse at 5, or 15 looking back at use of abuse. Every piece of her life was destroyed by that, and so I don't see where time ought to be a factor. I mean, this is from 0 to 18. Or I guess it's not even that old, is it? I'm not sure. Anyway, let's assume it's 0 to 18. 3 or more. I don't see any improvement from 3 within a week or 3 within a month, or it almost gets worse. If you could go through terrible trauma for 1 week, it might be actually easier to take than to say every 5 years you went back and relived your worst nightmare. So I think the bill as it's written is a good way to go. I like to.
All right, would somebody else want to talk? Oh. So, from what you're saying, 5 years old, child gets knocked down, terrible, but it's determined to be a second-degree child abuse, second-degree assault, or second-degree child abuse. Is that what we're talking about here? It's not a first degree. There's no weapon, no real injury. Okay, and then so, per bill, 5 years later, it would then be considered a course of conduct because there's no time limit, and then it would be it could be considered a first degree offense even after a 5-year lapse, even if the nature of the crime was still something akin to a slap, as opposed to like a physical burning, which I would think would be like a first degree.
Okay. So second degree can be a severe physical injury. So, I mean, I think that's pretty substantial. And the cases that were shared with me were that this is kind of amounts to torture over a period of time. And when you're talking about children, some of whom are too young to provide information about what exactly happened, I think it's important to hold the abusers accountable in this way. So I find myself in total agreement with Senator Castellan.
I have discomfort with the bill. I'm certainly not in favor of children being abused. I'm not convinced. I mean, we have a whole commission group that's looking at the penalties. Maybe this is something that should be looked at. But what I'm saying is that conceptually, under our current laws, we've made decisions about what's going to be second degree, what's going to be first degree. We're saying this is second degree, but because it's happened before, we're going to now call it a first degree. I just have a real fundamental problem with that.
Well,
I don't have a problem with a course of conduct within a time frame, but I have real discomfort with the bill as is.
So I just want to give you an example. So this was from the state's attorney in Prince George's County, she talked about a case, an 18-month-old girl who was brought to the emergency room for burns to her hands and difficulties breathing. The little girl was suffering from 12 different rib fractures that occurred on at least 3 separate occasions, 18 different bite marks that had broken the skin from 2 different adults, injuries indicating being whipped with the cord, as well as the burns to her hands. And the injuries all occurred within days and weeks of each other. And the medical diagnosis was torture, but it wasn't enough to charge a first-degree child abuse case. So this bill would help to close that loophole.
I understand why it wasn't enough. That doesn't make sense to me. That would be a first-degree assault in any other situation.
Well, this is coming directly from the state's attorney who I assume would charge the highest that she could charge in this circumstance.
But your concern is the scheme and how you're doing this to get to like some sort of enhancement. You're saying you're not. If there's a continuing course, maybe there should be an enhanced penalty for that, but don't call it the same exact offense just because it's happened more than once. It's automatically a different offense. 3 times. I know.
Come on. That's why I understand what my colleague's saying. But this is 3 times you're convicted. If you're convicted 3 times, it means you probably did it 100 times. Because how many times did you do it and you were not charged or found out? So,
Conviction, it's just that.
I'm sorry, you have 3 charges. I'm sorry, you were caught. You were caught 3 times.
Right,
Well, you were
3
accused
instances.
because there is still something
It's like
called a
drunk driving,
presumption of
When you
innocence.
drunk drive 100 times before you get caught.
And guess what? We don't make like the 3rd drunk driving offense a felony. We just say you have an enhanced penalty, right?
We do enhance it.
She's just talking about the scheme of how you get there.
And even though like biting
understand.
and burning is horrific, I'm sure it also encompasses much less, harsh things. Like what happened to me as a kid, getting slapped. Okay, like couldn't that also be included, or does it have to be something more severe?
Physical injury. So can I make a motion favorable?
And then Senator Sidnor, just go ahead.
No, I was just wondering, just following Senator Carter's line of questioning, I mean, what would be the time frame that you're thinking that these acts should happen?
There's no time frame.
Right, no, I know there's none here, but again, the continuing course of conduct, I mean,
Bob,
when I was listening to the testimony, yeah, if it's happening within weeks, I get it. If
Bob
it's
made a
something that's
compelling
happening
argument about the time frame.
years later, again, is that a continuing course of conduct? I think she raises a good point.
So when we legislate, when we discuss these issues, and we discuss, having some type of parity in how we make laws, I understand that whenever we talk about vulnerable people, whether they're children, defenseless people, or vulnerable adults, whoever, there's an enhanced sense of desire to protect them more. And I get that. But my concern is not only with this bill, like what is the next thing? Like next they're going to say, oh, we hate drunk drivers, they're terrible. So rather than have an enhanced penalty for a subsequent offense, we're going to just make a second or third time now a first-degree felony. I just think that the concept is problematic, what we're doing. We have elements of a crime under our current law. We say this is what the crime is. And now we're going to say it doesn't matter that the elements of the crime meet this criteria, but because it's happened or you've been accused more than once for it, then we're going to make it we're going to recharacterize it into a different, as if it has different elements. And again, that's really my concern. And then if we do it here, then what else? What next?
This is not precedent setting. We've done that before in the sexual abuse section that Jamie read. So
every other area of law where we have a course of conduct, we have a continuum. We don't say it could have been 5 or 7 years apart. In fact, in some areas of law, like DUI, 5 and 10 years, we actually allow for a PBJ to be redone, like it didn't happen the first time after a certain amount of time. So, like even in Cashley's little theft bill, his little theft bill, the course of conduct, it's not as if, in order to meet the standard of a course of conduct, it has to be a continuing conduct. It can't be that, you did it in 1972 and here you are doing it again. Like, we would not call that a course of conduct. That is really a problem for me. So I get there's a lot of will to pass the bill, and I'm sure, nobody's going to cares, but I care. I don't think it's the right way to do it. I think it should, any time we say there's a course of conduct, we need to spell out what that is. And it should meet some type of confines of a time period. And then anytime if we're going to say, well, because this is like happened 5 times within 2 years, then we're going to call that now the first degree thing. I get that. But the way this is, I don't think it's the right way to do it. I just really don't.
I was going to say, I think I would leave it to the court to determine what the course of conduct is. I appreciate your concerns. I hear them. But I would leave it to the court to interpret what a continuing course of conduct means.
That's not what we do when we say course of conduct in other areas. We spell out what that conduct is.
Did
Why do we treat physical abuse more harshly than sexual abuse? Like, there's not even parity now between sexual abuse and physical abuse. Does that make sense?
Oh, so it's just the bill? It's just the bill? Oh, okay.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Pass.
We're missing 2 members.
Senator Carter.
No.
Senator Huff.
Yes.
Senator Castley.
So I'm very concerned by what Senator Carter says. I think she makes a really good point.
Voted.
No, she makes a really good point, but I think it's an area that's screaming for legislation, so I'll say yes and let the courts fix it. Thanks.
Well, yeah. Senator Sidnor.
I'm hearing what she's saying as well, but I'm feeling like Castley on this. If I can, before I cast my vote, can you all? What has happened in the House? Do you know?
It passed the House and it's pending before this committee.
The presumption of innocence is over.
Yes.
Chairman Smith.
Yes.
Really quick, I just want to make a comment. So Senator Castley, yesterday I had occasion to look at a Court of Special Appeals argument, and a judge on the Court of Special Appeals named Arthur basically commented that we are just a bunch of idiots over here. Like the attorney was arguing, well, if the legislature had intended for this to be in this category, they would have done it. And he says, you're talking about those people across the street, across Raul Boulevard? Please.
Hey, where's that bill to lower the judges' salaries again? Let's go ahead and pass that. Let's make that emergency legislation.
A vagueness thing, and it may be that we run into constitutional problems for vagueness, and the court will tell us, right? If that's too vague, I mean, a course of conduct, what's the course? And so you make a good point, Senator.
Shit, Susan, so what? So we're holding 5:30, right? We said that earlier. Let's move it in tandem. Huh? Yeah.
Can I do a Sandy time?
That's not Sandy though. Is it Vicky? That's Vicky.
Oh, is it? No, it's Terry.
Oh, it's Terry's, right?
Yeah.
Let's do. We do 583. We have to hold that one for one more. Okay. Yeah.
That's Jamie's bill?
Jamie. 583.
Yeah. I mean,
Just keep working our way down.
sure. So 583 requires the body-worn camera policy of the Maryland Police Training and Standards Commission to require that a body-worn camera purchased or otherwise procured for use by a law enforcement officer on or after January 1st, 2022, automatically records and saves 2 minutes of audio and video footage immediately prior to the officer activating the record button on the device. There was some feedback from a state's attorney in Baltimore County about a potential conflict with the current wiretap statute, which essentially currently exempts the recording through a body-worn camera from the wiretap statute if the law enforcement officer meets a couple of requirements. It's 5 requirements that need to be met. So the issue that was flagged with that was that they wouldn't be able to notify, I guess, every single person 2 minutes in advance before hitting record. So there is an amendment in your voting packet. It is Amendment 583121/1. I'm sorry, Senator?
It doesn't look like the amendment is correct.
Okay. Yeah, this was just the one that I received
Yeah.
from your office.
So
but-
there was a delay in, can we hold this? I don't think the amendment is correct. So I need to go back and, I don't know why. Yeah, but can I talk a little bit about?
Absolutely.
So the idea here, if you recall, was that the bill allows for the pre-buffering audio and video 2 minutes prior to the officer turning it on. So there were some concerns from my state's attorney about wiretap laws, and what we'd like to do is just limit it to video. And then actually on the amendment, let me look here. The section of the amendment that's correct is, actually, I'm not even going to refer to that. So we have some definition of exactly what a body-worn camera is that will include, but I'm happy to talk about the time frame too. The 2 minutes is the capacity, 30 seconds is the kind of standard. And I'm happy to discuss that if folks wanted to discuss that another time. And I will go back and find out what happened with the amendment.
Thank you, Mr. Chair. I am in the process of slowly making my way through the policing bill passed by the House, and I believe that it provides for 1 minute,
It does.
not 2.
So there is a 60-second provision in the House bill that also has the provision about the collective bargaining sentence here on C, page 3 of the amendment. A law enforcement agency may not negate or alter any of the requirements of this section through collective bargaining. It also has that provision in, and it also limits it to audio. So I would be fine to comport that with what's in the House version. And there's one other piece that I'd like to include that's not in this amendment here.
County and said it was going to cost like $1 million to do this. And my concern is, we just tried to figure out how to, for just your county was $1 million, I believe.
Yeah.
And we just went through trying to figure out how to get the state up on body cameras and get them to afford it. And then we're going to try to go to figure out these small jurisdictions and impoverished counties, and then we're going to throw on another requirement on top of them. And with all due respect, the incident that you showed us was from another state, correct?
No, it was from Maryland.
It was from Maryland?
Correct.
Where?
The city.
It was from the city? And so, but nonetheless, when we're going through these, we're trying to figure out how to get everybody set up on these cameras, and then you're going to add another $1 million just for your county on top of it.
So it's not $1 million if you just do audio, just do video. It's
Just
far
do the
less.
video?
Yeah, it's far less.
And so Schellenberger's okay with this now?
He seemed to be in my email exchange with him, but
I mean,
will
I
get
still don't like the
confirmation.
fact that they had turned on a video camera and start videoing you without telling you. I mean, that's an invasion of your privacy, quite frankly. Come in your house or whatever, start videoing you, and it's all public before they've even told you. Catch people in state of undress or whatever. I mean, quite frankly, for your concerns with public safety, my concern is about the privacy and the state and the government recording you, and now recording you before they even told you they recorded you.
Again, that's what the people in his office do, is when there's circumstances like that would arise, it would be redacted. So.
No, but it would be redacted if I ask and I know. What I'm saying is I don't like the state and the government recording me without my knowledge. And right now, we put in this whole thing, went back and forth with the Maryland Police Training Commission about a requirement. They tell you, I'm going to record you. And obviously we say, well, in certain instances they can't because they just turn it on or whatever. I just don't like the government going around recording people without their knowledge, whether it's video or whatever. I don't want them coming in my house or my kids or whatever and having it's done their business.
So the House, they did 60 seconds audio and video?
No,
Just video.
Video.
And then, so just the council then, about the cost question, because I was under the impression that, like, I know that.
Which, by the way, hold on, one other thing we're thinking about on this. If they're going to go plant stuff, you don't think they're going to figure out how to get around this? If they're like dirty cops or whatever,
Yeah.
they're just going to turn on their camera 3 minutes later. Hey, if you've already crossed the ethical line, I'm going to go plant a gun or drugs on somebody. You're basically, this would catch stupid cops who are like, don't figure out to time it. Well, it used to be 30 seconds, but now it's a minute.
All right,
but I forgot. No, it's true. It is totally true. If they're
I understand that.
The point of it, no, well, let me finish my point. If the point of it,
you cut me off.
I know, but it's a larger point.
Excuse me for interrupting you while you interrupted me.
The point is, the efficacy of it's little, but we're going out and we're setting up this Orwellian nightmare of recording people all the time.
Got it. So back to my question to council, though, is, look, Montgomery County has unlimited storage. I was under the impression that all this is like, once you have a contract for storage, it's kind of, the cost is preset. The cost is what the cost is. Is that different from the 3 jurisdictions that have body cameras right now? Do they have different storage plans and different costs?
So Montgomery County, just for the fiscal note purposes, they came back and advised that they have unlimited storage for the camera footage. Prince George's County, they advised that they might experience additional storage costs, just given that there's an additional 90 seconds that they're going to be looking at storing.
All right, so look, well, when you come back with your second part of the amendment, we can just adopt if you want to conform with what the House did in their package, then we can see what the other language looks like as well. Do you want to, still want to do that?
I'd like to hold it, so
Okay.
60 minutes.
Okay. So we'll hold it. All right, we'll go on to Senate Bill 592.
This bill alters the contents of the department's annual report on child welfare performance indicators. The bill alters the information required in the report by including 5 additional pieces of information about children and foster youth in the state child welfare system. There is an amendment in your packet. It makes a technical correction because foster youth are children under the care of DHS who are in out-of-placement. Therefore, they do not receive in-home services. So it's a technical correction requested by the department.
All right, can we adopt the amendment? All right, everyone's good with that. Okay, great. Questions, discussion? So we're on Senate Bill 592. Make sure everyone gets a chance to read it. Don't I know? All right, there's a motion for a favorable as amended. It's been seconded. Is everyone okay? Good, all right. The bill passes as amended. Senator Vice, and then Vice Chair Wallstreger.
This bill expands mandatory participation in the Ignition Interlock System program to include an individual who is granted probation before judgment for driving while under the influence of alcohol or under the influence of alcohol per se, including for an offense committed while transporting a minor, and an individual who is convicted or granted a probation before judgment for driving while impaired by alcohol, including an offense committed while transporting a minor. Just to clarify, under current law, with respect to impaired driving, participation is only mandatory for an individual convicted of committing an offense while transporting a minor younger than 16. The bill additionally makes various technical and conforming changes.
you, Mr. Chairman. So this is an important loophole to close. To the extent there's any debate, I think the police officers on our committee would be helpful to it. So can we just put it at the end of the calendar? Sure. Come back to it.
All right, we'll put it at the end of the calendar. All right. So we'll now move on to Senate Bill 686. Remember, we recommitted this just because I forgot to tack on an amendment. So, Senator, actually, so Heather, that's you, right?
So I did draft the amendment. I just forgot to put it in your packets. All it does is this was the HOA condo bill from yesterday. It struck the language except as otherwise provided in this title or in the governing documents and replaced it throughout the bill with notwithstanding language contained in the governing documents. That was requested by the proponents of this bill because their concern is that the governing documents predate oftentimes the adoption of Zoom type meetings. So if the governing documents contradict this bill, then they'd have to go in and amend their governing documents, which would defeat the whole purpose of this bill. So they just want to add the language of notwithstanding language contained in the governing documents to authorize the groups to do this if they so wish.
So the amendment's been moved, seconded. Is everyone okay? Can deal with this. All right, motion for, okay, move the bill, second. Everyone's okay with the vote for last time? All right, thank you. All right, we'll now move on to Senate Bill 690. Senator Sidnor.
Senate Bill 690 sets forth the circumstances under which a custodian of records must deny or allow inspection of recordings from body-worn cameras worn by law enforcement. The bill's provisions do not apply to a public record that has been entered into evidence in a court proceeding, and the provisions may not be construed to affect the discovery or evidentiary rights of a party to a civil suit or criminal prosecution. So the bill lays out circumstances under which the custodian must deny inspection, and also circumstances under which the custodian must allow inspection. And then thirdly, it sets out provisions that prohibit inspection or copying, but those would apply to recordings from body-worn cameras by copying by individuals who are under investigation for, charged with, have received probation before judgment for, are subject to peace or protective orders as a result of, or pleaded nolo contendere or guilty in a case where the recording is of the incident leading to that investigation, PBJ, order, charge, plea, etc.
Did the amendment go out to everyone as well? There was an amendment from Chief Fitzgerald that should have been just, you didn't get that? I guess we gotta hold it. Yeah, thank you.
All right, so we're going to hold it for the amendment. Have you drafted it already? You submitted it already? Okay. All right, let's go back to Senate Bill 691.
Senate Bill 691. This is the bill dealing with the the reusable tenant screening reports. There is an amendment in your packet by the sponsor. So that is 853021. That it's the same as the amendment that was introduced during Tuesday's voting session. The bill was held for an additional amendment, which is 203524, Senator Huff. Is this the right amendment? Yeah. So this one, so Senator Huff's amendment, it does not conform to Senator Heddleman's amendment. Instead, it strikes subsection D, specifying that a prospective tenant provides a reusable screening report to a landlord that accepts reusable tenant screening reports. The landlord may not charge the prospective tenant a fee to access the report or an application fee.
No, 691.
691, the reusable tenant screening report. It establishes a reusable tenant screening report that must be prepared within 30 days before the tenant uses the report. So it lasts about 3 days, and it can be used at any landlord who accepts it. And then the amendments are more of clarifying in nature. Senator Heddleman's amendments. So subsection B goes over the contents of what the screening report must include. Subsection C goes over notice, whether or not the landlord accepts these screening reports. Then subsection D prohibits a fee being charged for the reports by a landlord who accepts it.
So this is entirely voluntary. So the landlord has to want to participate in this. This has been I think it's a really creative and innovative approach to a tenant having to file multiple screening reports and pay multiple fees if they're going to different landlords to try and rent a place. There were some concerns about security, and there were some other concerns. I will tell you, we sat down with CDIA, we sat down with MMHA, and came to this consensus. I would ask the committee to resist this amendment. I mean, the point is that the tenant pays the fee to a screening agency, and they pay it once. And the whole point is to prevent them from having to repeatedly pay each time. This is a screening report that includes the information that the landlords want included, and the landlord doesn't have to take it. But if they do, then they can take it and use it, and the security is all, the landlord accesses the report from an online portal, not directly from the tenant, and they can be assured that the information there is correct, and there are other provisions to make sure that happens. So I'd ask the group to resist the amendment.
Got it. Before we go to health, did we adopt these already? No. Shelley's?
Oh, I moved to adopt my amendments.
So did you put these forward yet? I stepped out to the bathroom for a second.
Yeah, I would move to adopt the amended bill.
Okay, so did we discuss these amendments yet?
That's what
Okay.
you just went through.
The previous voting session, and then it was held because Senator Huff wanted to get an amendment.
Got it. Okay. So Senator Heddleman, we can adopt these amendments, and then we'll entertain Senator Huff's amendment.
Yeah, I would like to adopt. I move to adopt these amendments.
I mean, are they consistent if we adopt one?
Yeah.
Yeah, because you just strike the fee piece, right?
Yeah.
Okay. All right, so is everyone okay with adopting it? Okay, great. So now let's go on to Senator Huff's amendment, which is 203524/1.
So if you just want to keep looking at the same document, if you have Senator Heddleman's amendment, you can just go down and strike subsection D, as in dog, which is on page 2, lines 17 through 21. So that's what Senator Huff's amendment does. It would strike all subsection D.
Yeah, I mean, just to be honest, I don't understand this bill in that, so the bill does three things. One is it says there's this rental application that they may or may not use. You don't need a law for that. That's irrelevant. That part, they can use or not use whatever they want. We could not pass a law and that wouldn't change. The next part it does is it says they have to provide notice that they take it or not. With all due respect, the large corporate people, they're going to know about this. They'll provide it. The small people that rent out a townhouse, they're not going to know. So they're going to probably be the ones that are going to run in compliance. I'm not touching that part, but I'm just talking about the actual, we don't need to take my amendment or not. I'm just actually trying to figure out the point of this bill. And then the last part, you say, well, if they do decide to take this, they can't charge anything. Who would take it then? So I did check with all the groups, and they're not all in favor. The realtors don't like it because they want to be able to charge a fee. They have administrative costs, and if they want to go back and double check, they want to do it. But everyone else is probably okay with this because they're not. This doesn't do anything. If we pass this bill, what does it accomplish? They can already take the fee or not, and they'll put somewhere, I don't know, on their website or on a signing form or something, this one little sentence on C. And then they're going to use their own one. Because if you tell them they can't charge a fee for their administrative costs or whatever, they're not going to use your form. So the efficacy of this bill, I don't think this bill does anything. Yeah.
The purpose of the bill is to prevent a tenant from having to pay multiple fees each time they go, to do multiple same repeated screenings, right? So they do this one-time screening. It includes all of the information that the landlords wanted to include. And then they can go to multiple places and say, I already have in the cloud or wherever an XYZ company that has already done my screening for me. You can just access it here. So there's no additional cost to the landlord.
These are all
either.
things they can do without us passing a law here.
No, but they can't because the tenant has to pay each time. Right
And
now.
if I decide that I'm making a racket off this $25 thing, which I doubt they are, the state law caps them at $25
Right.
non-refundable.
Right.
If I decide I don't want to take your form, because the other problem is they don't like the form because they have their own form or they don't want the person entering the information like that. So if they don't want to take it, they don't have to, and they can keep charging the $25 right
Correct.
now.
Correct.
So I'm saying the outcome of this bill, if we pass it, is Zippo. I don't think this bill does anything, and I would just prefer we just not vote for it because I know we don't defeat bills anymore in this committee, but this bill doesn't do anything. We're
So-
putting something in the state law that says they may or may not take a form. That's already, they can do that already. The only
So-
thing this does is a notice requirement. It's going to trip up somebody. If you're saying, and the other part is, you should actually take my amendment. Because if you say they can't take the fee, they're not going to take this form. They're not going to want it. They'll say, no, thank you. I'd rather my secretary or my assistant who does this work and process them, I'd rather get $25 to help cover their costs. So I'm not going to take your fee, take your form. Thank you. Have a good day.
Okay, so a couple things. One is this has been done in Washington State, and people are taking them, and people are using them, and tenants are saving money because of it. So I do think it does something. I would love to come in with a mandate to do it, but I don't think this committee would have the stomach for it, nor would the industry. So this is an opportunity to see if it works and to save tenants money and provide landlords with the information that they want when they screen tenants.
All right. Further discussion on the bill.
Make a motion for favorable.
Sorry, I'm going to motion on. We'll entertain a second. Senator Castley, go ahead.
I didn't have really strong feelings on this, but after reading the bill and the amendments and the various pieces of the record, my current concern would be that what this would enable is a tenant could just start whipping out applications to 100 landlords all over the place, and landlords would have no indication whether they were actually a serious tenant. So you're going to review this report and spend time reviewing it and confirming some stuff and processing an application, and then the tenant just disappears. I think the opposition makes a really good point that you're gonna undermine the utility of these things rather quickly once the landlords realize that they're not reliable. So they're gonna have to tie up rental units and stuff where a tenant has no commitment at all. They just pop these puppies out across the internet, and pretty quickly, I think we establish that they're not really worth anything. So I think the concern that you're going to destroy the utility of the very thing you're trying to promote would pretty quickly become apparent. And a landlord, if landlord could charge $5, $10, $50, whatever. I mean, if it's impinging upon the tenant, then those landlords won't get as many applications. So, thanks.
I think that's a misread, with all due respect. I mean, this has been in effect for a few years in Washington State, and that has not been the case there. I don't know what the incentive would be for a tenant to do that, because I think a tenant is seriously seeking housing, and this is just a more direct, again, more consumer-friendly way to approach the screening that all tenants have to go through when they're trying to get housing. And that has not been the real life experience in the state that this has been in effect.
Senator West, and then I got a question. Go ahead.
Yeah, I'm looking at the statement of the Maryland Realtors, and it says, although a landlord would not have to charge as large an application fee if the landlord accepts a reusable tenant screening report, the landlord still has administrative expenses processing applications. Which makes sense. So I can see saying, having in the bill saying you can't charge the same fee you otherwise would charge if the landlord had to do all the work. But it seems to me the landlord still ought to be able to charge that fee which is appropriate given the work the landlord would have to do to examine the report and make a determination.
My only comment to that is the landlords were willing to forego that here in this bill as amended. Right. So they were willing to compromise on that. I mean, they were willing to forego that. So.
Go back to Senator Huff.
Yeah, the state law is currently, Senator West, that they can charge no more than a $25 refund. The non-refundable portion of anything they can charge is only $25. That's it.
It's not a lot of money.
That's it. So what this bill will say is they may or may not use this form. Don't need a state law. That will affect nothing. There is a notice provision that they accept it or not. Okay, and it can be like anywhere on a website, another form, or whatever. And then it's if you do accept it, you may not charge this $25. So what are people going to do? They're not going to want to accept it. So it's actually, I was wrong when I said it doesn't do anything. It actually probably does the inverse of what it wants. If they want people to take these by saying you may not charge a fee, they go, I can't charge the $25, then my people process it and go back and look. They'll say, yeah, forget it. No, I'm not going to take them. So that's what I'm saying. This is not, I don't think this is a good law. I don't think this is a good idea. I think at most it does nothing. And the other ways it does worse because people are going to take them. They can't charge the little $25 refundable fee.
Well, let me ask you this: for the applicant, I mean, I know there's obviously cost savings associated for the applicant if you have this, but for the actual landowner, the property owner, does this cut down on the administrative fee piece? And one, just because it's kind of already pre-populated, it's already good to go. Background checks don't have to be, nothing has to be done. It's already done. So would that cut down on their administrative side of the house?
But and they would say that the $25 fee already probably doesn't cover their costs. I mean, they're not making money off of these, right? The landlords. But if they take them, I'm sure it saves them. Yeah, it saves them some time and some energy and some resources that they don't have to do it. It's already, they've subscribed with this company that already does it. No, they can't. Not for the tenant. They can't. They have to.
They can already use they can already use this form. A landlord can use whatever form they want, and they can already use this without us passing a bill.
The tenant cannot. Tenant
Why would you say a tenant can't use this form without us passing a bill?
Each time the tenant goes to apply to building A, building B, building C, they have to pay the $25 charge at each place and have a redundant process gone through in each location.
Yeah, but what?
If I go to 4 different apartment buildings, it's going to cost me $100 as opposed to $25.
I understand that, but you're thinking that everyone's going to go by this bill, and if they don't, which is up to them, they're still going to charge $25 to use their own form, 25, 25, 25.
Correct.
If through the market, they choose to use this, whether we pass this or not, through the market, they choose, they say, wow, this is great. This is a reusable form. We can use it. It saves us money, saves us time. Through the market, without us passing a bill, they'll use it. Whether we pass this bill or not, it will not affect that.
But there isn't a market right now. We're helping to create a market by bringing this innovative approach to saving tenants money.
Well, I would argue
that's
whoever makes the reusable form makes the market. Whether we pass this or not, we don't legally change whether you can use a reusable form or not. All we're saying is if you use it, you cannot charge a fee for it, which is a disincentive through the market to use that form.
It hasn't happened that way in Washington State. It has saved some
From what I heard
tenants
from Washington
funding.
State, the impact was
Let her
basically
fin- let her
not
fin-
very
let her-
much.
Let her finish off the sentence. Let's dialogue back and forth, back and forth. Let's stop cutting each other off.
I'm not
All right.
saying
I'm
that
done.
this
I mean,
is.
I think I've said my points on the bill.
I'm not saying that this is going to change the world or it's going to change landlord-tenant relationships. I'm just saying this is a consumer-friendly approach that will help save tenants money. And that's it. No. Is it going to be earth-shattering? No. Is it a foot in the door to perhaps an expansion of this kind of program and more consumer-friendly approach to renting? Yes.
So, to the maker of the bill, so are we essentially saying, explain to me how, so this is a universal form that will be used for rental properties in a jurisdiction or the state or in the state?
This, and they provide, they do the screening, they do the security screening in the background and the credit checks and everything that a landlord may want. And then I go online and I pay my fee and I put in my information and it's uploaded and if I go to building A and they participate, then they go to the portal of the company that has done the screening and they access my report.
Similar to some of the employment programs that are out there. So I think, so is this enabling for, so if I own, Jackson Management.
Yep.
So I am not required to engage in this process.
No. You are not required to.
Okay. All right. Thank you.
Senator West, Nana.
So I'm trying to think, if I were a tenant and this bill was law, and I wouldn't have to pay any fees, what I would do, and I think what I'd do is I'd fill out the form, and then I'd shoot it off to 25 or 40.
You can't shoot it off.
I mean, you can't shoot it off.
It has to be accessed by the landlord. So you'd have to go and apply to different landlords. You're not going to take it. If I'm the landlord, you can't send it to me. The company that has done the screening sends it to me.
Okay, so the tenant tells the company doing the screening, please send it to the following 40 management companies around the greater Baltimore area, and I don't have to pay $25 a piece, so I'm getting 40 companies to analyze the form.
Not 40 companies, one company. Well, you have to fill out all the other paperwork that you would to apply to rent in those 40 buildings.
I'm just concerned that a lot of landlords are going to do the processing work, and then the tenant's going to say, I choose you. And 39 companies are going to process the material and gotten nothing out of it, and that would lead them pretty quickly to say, I'm not going to take these forms.
I just don't think practically that's not how it would work. I really think that somebody has to go and fill out the form that they're interested in building A, B, and C, and then they would do what you're saying.
And is there an application fee associated with that?
I think that's up to each different landlord.
Okay.
So I do I got to tell you, so I see the obvious benefit for a potential tenant, because you've got a single piece of information, you've got one background, you submit it, but it's got to work together. There's got to be an incentive for the landlord, and I know that the reason it's a control cost, but if there's no financial incentive apart from just maybe the administrative cost of doing a separate background check and separate, checks, there really isn't, is there an incentive for them to participate in this? I'm just worried about that we'll set the framework up, but it's voluntary, and there's no financial or administrative incentive if they can't charge something, or if we can't prove that enrolling in this process streamlines the process so much that it cuts down on their administrative costs, which I just have no window into that.
I think it streamlines their process. Plus, I think it is a consumer-friendly approach. So you can market yourself as accepting these, and that is appealable, I think, very appealable to tenants. So again, it's starting the marketplace.
No, I get it. I think that's definitely something that would entice applicants.
Yeah.
But there still has to be, at the end of the day, like some sort, you know what I mean? Like there's got to be some sort of incentive for streamlining and for cutting down on cost. And I'm just trying to figure out, I don't know enough about what the marketplace looks like and how things work here, but
yeah,
it just seems like there has to be an incentive on both sides a little bit to participate, because if we're making it voluntary, then why would you choose to participate? I mean, apart from maybe being a marketing thing to, but
I think that's significant, that a marketing thing, and that you, yeah, I mean, I think that's significant. And then it kind of catches on to more landlords.
Yeah, just a quick, I mean, was there any indication that landlords are charging an inflated processing fee that's killing this whole thing?
We cap it at $25. But again, it's the $25, $25.
It just seems like we're wading into a private commerce area that doesn't need us to wade into. That if we thought that people were being nefarious here and gouging on these things and somehow taking advantage of poor people, but if it's a moderate fee, which they're going to charge because they want people, I mean, they want applicants, they want to fill up their rental units, so they're going to charge something I think is fair and reasonable, so they get the maximum number of people applying. And I'm just hesitant for the wisdom of all of us landlord tenant experts in the Judicial Proceedings Committee to override the lifetime experiences of people who work 24/7 in this industry. That's just my concern. Thanks.
So, but the people who do spend their lives doing this are comfortable with it. The MMHA, those are the people who, participated in this process, and they're comfortable with it. I think they see this also as a national model after, Washington State did this. If we do this, I mean, they played heavily in putting what they thought was important in this. I don't think I'm saying anything out of school by saying that they're entirely comfortable with it.
MHA's members can do all of this without this law. If they like this, if this is a good idea, they can do everything in here and more. They can pay people a bonus to apply. They can go the other way. Apply here, we'll pay you $100. They can do anything they want, and eventually, I mean, presumably the MHA people, if you're right, the MHA people who do this will have better tenants, and their practices will bump out of the market people who don't allow that, and they'll get all the good tenants, and the other people aren't. If MHA's membership is like, let's roll on this, then hey, you don't need us at all.
I was just going to say, to the chairman's point, that's why I talked to the Association of Realtors, that's why I offered my amendment, because I think there's actually a disincentive to do this, because right now they can do this without the law. If you add the bill in saying they can't charge the fee that they would normally charge on other applications, now you are disincentivizing them from using this. So rather than have the market take hold, let it work that way, you are disincentivizing them, because unlike other applications, this one they have to treat differently and charge nothing on.
And that's why I was talking about I don't have a window into how this works, because I mean, if it's streamlined and they're cutting down on administrative cost, then you could charge a lower fee, a much lower fee, to make this application more enticing for both ends. It'd be like a low fee for the potential tenant, and then it would cover or more than cover some of the costs normally associated with onboarding someone for the landlord. But I don't know enough about the numbers to understand that. But Senator Carter.
I understand the concept of the bill, and I like the concept of the bill. I also think that it's really important to try to save people that are apartment shopping some of the cost of multiple applications, and especially if they're rejected, and then they have to go and do the whole thing over again. So I'm really inclined to pass the bill. I don't think it's perfect, but perhaps it's a floor, and it's a beginning of a process that maybe we can tweak later and improve on when we see some of the failings of it. But for those reasons, I support the bill and ask that we move it.
Is there? I'm just tossing this out there to the sponsor of the bill. Is it? I mean, just based on your conversation, if a fee were to be like a, let's say, $5 fee or a low fee, whatever the fee is, a low fee, something, because you want the landlords to be incentivized to participate. I know it could be a marketing thing as well, but it seems to me that there isn't enough incentive to participate, and then you wouldn't,
$5 fee. I mean, the fee aspect of this is like not a issue for them. It's really not an issue for them. So, again, I do think it's probably saves them some costs because they don't have to do what they have put in place to do the screening themselves. They can rely on this other company to do it. So it saves them some administrative burden and some administrative costs. And again, I think it's very appealing to consumers. I'm not sure I have much more to add. And again, we have the experience of Washington State. Is it, really widely used there? Not hugely, but it is used. And it's, like the senator said, it's a foot in the door and it's a floor upon which we can build.
Why don't you suggest a $10 discount? If you use this, you get a $10 discount.
Senator Jackson wants to speak on it. Good.
So let me ask you a question. So do we need a law for this? No. I mean, look. My concern is, I think there are a number of such models that are out there. So you're coming out of the military, you want to apply for a job in a certain industry, and you may be able to go to a site and you put your application in, and it gets run there, or for.
Right? It's very similar to the Common App.
Yeah, and so I'm just wondering, and that's why, hence my question, do we need a law for that, or could businesses actually just engage in that practice and then do their thing?
I suppose they could if they wanted to, but, if they, again, I think this is a forward-thinking, creative approach that's consumer-friendly. That's why we put it forward. We think it helps people in this housing-burdened, arena that we're in, where things are costly. It saves folks a little bit of money.
Understood.
I was going to say, look, it's a great idea. I think it's a great business. I think it's great, whoever does this. But look, it's a great idea, but we don't need a bill for this. I think this bill may actually underdo what you wanted by saying they can't charge the fee. We don't need a law for it. And so, look, I know we have not been in the mode. We used to be in the mode. We used to shoot bills down all the time. It's not personal at people to defeat a bill. It's not personal. You got a bill up prior to this, 2 ones before I liked. It was all behind. I do not think it's the policy's good. I actually agree with the policy. We're like debating or saying, I just think this doesn't need to be a law. It doesn't need to be in law. I think it may actually do a disservice to it. I actually don't think it does anything, the bill. That's why I don't want to put it in law. So I just make a motion unfavorable on it. All right, how many bills Senator West, I'll give you this, and then we got a motion before us. So Senator West, you go ahead and talk, but then we got a motion. It's your motion is before, but go ahead.
I thought that the reference to the common application college is a pretty analogous one. So most of the kids these days applying to college use the common application, but there remains a fee. The colleges all want like a $50 fee to apply to college. So if we passed a law that said if a college accepts a common application, it can't charge any fee, my guess is a lot of colleges would stop taking the common application because all those fees in the aggregate help to offset the cost of the admissions office. So,
Wait.
what did I do wrong?
No, I mean, nobody is saying that they're not charging a fee to apply to the landlord. It's just for this particular thing. I don't think colleges charge for taking the Common App, right? They charge a fee to apply to the school.
The Common
same
App
thing
is the
here.
application. So with the Common App, the student gives $50, and typically these days students apply to 10 or 12 colleges. Where back in my era, because it was more expensive, and each application was different, you'd only apply to 3 or 4.
Right.
Now with the Common App, you can just splay them all over the landscape at $50 a piece and see where you get in.
I think, look, we got a motion. I think, I like this idea as well. Actually, I really do like this idea, but there's got to be an incentive on both sides.
And if there weren't an incentive on both sides,
Saying we don't want this, and they're not there. So
It will never
they're
create the
not.
marketplace because they'll never
not the
participate.
landlords and not the credit
All right,
agencies.
Senator Bailey. And then look, yeah, go ahead.
We're arguing, it seems like right now, for the sense of arguing, I would like to second the motion for unfavorable.
Yeah, so wait, for just real quick, are you withdrawing your amendment now then?
Yeah, we're on unfavorable motion.
So you would,
We never were on my amendment. We never
I thought we were,
motion on my amendment.
Okay, but you're not putting it forward, so we're.
Well, I made it unfavorable. Yeah, my amendment was never formally offered. I made it unfavorable in a second.
okay.
Vice Chair Waldshaker.
No.
Senator Lee.
no.
This is unfavorable?
Yes. Yes, unfavorable. Senator Castelli.
Yes.
Senator Heddleman.
No.
Senator West.
Pass.
This one, guys, we can kill one.
Senator Signor.
We can do this.
Pass.
Senator Jackson.
You know, it's kind of, it's tough for me because I was going to pass. Pass.
Oh.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Going back to West. Senator West.
Yes.
No.
No.
We need 2 more.
Senator Sidnor.
No.
Senator Jackson.
Is this on the unfavorable?
Correct.
I think the bill needs more work than to kill it. It's, no.
Chairman Smith.
What's the call? Where are we?
We are 4 yeas, 6 nays.
All right. So look, I'm gonna go. I'll go no on this because look, it's before still, so the unfavorable fails. But we are going to. This I think we can fix this. So let's hold.
You can take my amendment.
Let's fix this. Let's talk. Let's hold this. Let's hold this. I think we can fix this. But I'll vote no on it and whatever. All right, Senator Feldman, 726.
This bill authorizes a personal delivery device, or PDD, to operate without registration on any highway, sidewalk, or crosswalk in the state. The bill excludes such devices from the definitions of motor vehicle and vehicle and establishes various other standards and requirements that must be adhered to by devices operating pursuant to the authorization. So you have one amendment in your packet. It's number 993, 126/1. It does a number of things. So it allows PDDs to operate on footpaths and bike trails. It allows PDD operators to participate in the MVA's self-insurance program, which is a program whereby an operator who has a large fleet of vehicles can essentially show to the MVA that they insure their entire fleet, rather than being required to carry an insurance policy for each individual vehicle. It increases the maximum weight of a PDD to 550 pounds. It clarifies the definition of hazardous materials by reference to federal regulations. It increases the max speed at which a PDD may operate from 3.5 to 10 miles per hour. It requires PDDs to obey traffic signals. It requires PDD operators to submit an emergency response plan to MVA, which would be made available to law enforcement agencies in the state. It requires PDD operators to inform counties and municipalities before they begin operating PDDs. It prohibits PDDs from operating on any road which has a sidewalk or a shoulder or a speed limit above 35 miles an hour. And it requires the MVA to develop a permitting process to allow the use of these PDDs in the state by October 1, 2021, which would be in effect until the rest of the bill goes into effect, which under the amendments, that date is pushed back to July 1st, 2022.
All right, questions on the amendments? Okay, Senator Sidnor.
Before we're adopting anything. And I was saying this to Senator West when we were hearing testimony about this. One of these amendments, it moves the speed of these vehicles from 3.5 miles or 3 miles per hour to about 10. And if they're on our sidewalks, I mean, I can imagine this thing speeding past elderly people, just people trying to take a stroll, and I don't know if you want something that fast on your sidewalks.
Yeah, is that a question for council? Is that what it says?
No, I guess your opposition is 10 miles an hour?
I don't know why. I mean, it's like 3 times faster than what it was when it was put in. I'm not certain if.
I don't know, it's 10 miles an hour. That's my dog walks like faster than that. Is that fast?
I don't, but we're talking about a vehicle.
Yeah, it was those little robots.
Senator West.
As I ran, and I never ran at 10 miles an hour for very long, and I thought I was running pretty fast.
You weren't. No, I'm just kidding.
Vehicle where they have set the speed limit for, I think 10 miles is also very high, too. Why was 10? How was 10 reached?
So I believe the amendments were formulated by some of the companies' estimates. I walked through the amendments with FedEx, and I don't think they explained to me the speed limit part. I'm not sure if there was a reason for that or if that's one of their main concerns. But
Is there a similarly type vehicle that is used that's like Scout? Is it Scout?
Sorry, I didn't hear that sentence.
Is there a similar type of vehicle like Scout where there's a speed limit?
I can look
I just want to know how they arrived at 10.
Yeah, I can take a look and see there are certain types of vehicles that may have specific speed limits. I'll take a look for that.
I agree with Senator West and Senator Signar. I think that is a little high, especially with seniors walking and children, and because it's a vehicle. It's a vehicle. It's not a person.
Hey, Josh, looking at the testimony on behalf of the bill, do we know what other jurisdictions or states have done in terms of the miles per hour?
I think I have. I'm not sure. I can take a look and see the specific, if there's a speed limit on the other states. I know some.
Why don't we do this? Does anyone have? Yeah. Senator Huff.
I mean, this thing is like, it's not going 10 miles an hour the whole time. You're using the robot. It knows people in front of it.
I'm trying to think proactively about having these. I mean, it's one thing going in the street, but it's another thing when you're on the sidewalk. I mean, and I don't recall any testimony that it is coming up on you if it anticipates that it's coming up on a person that is going to drop in speed so as not to zoom past somebody and the like. I mean, when you're thinking 10 miles an hour, I think in most neighborhoods the speed limit is about 20. So it's going half the speed of what cars are going through on a sidewalk. I mean, that's my thinking. I mean, I'm fine with the bill. It's just I'm wondering if that's too fast.
Thank you, Mr. Chairman. So I've had an occasion to do some bike riding, right? And it depends on where you're doing the bike riding. I mean, there are studies that say flat land, you want to try to keep 17 miles per hour up and down. You know what I mean? So 10 miles per hour is pretty fast. Now, there's some technology that are in vehicles, cars, that, at a certain rate of speed that vehicle will stop if there's something in front of it or at least begin to brake. I didn't hear that in the testimony. I think a contraption that sits, is compact, and it sits the way it sits. If a child darts out from a stairwell and jumps in front, accidents happen. Accidents aren't planned, right? They happen. And, I think 10 miles per hour is a little too much. I don't know where the amendment came from, but I just think, the FedEx driver who jumps out of the truck and runs up the steps is one thing, right? Not the machine that's geared to go 10 miles per hour. So I think we need to be a little careful with that. I love the contraption. I understand what it does. But I think when you put that much speed, to an object, I think we're just asking for trouble. So if that's an amendment that's on the table, I would actually reject that, put it back to where we were.
So there's some unreadiness on the speed, so you want to just hold it for all.
We don't know what we're doing. I don't want to mess up if Amazon or FedEx has a million of these things, and then we set up something that makes us different. Can we just go back and then we'll talk to them and find out what we're a small market in the world of FedEx and Amazon, so I'd like to figure out how these robots work more. We can hold it for one, right?
Yeah, it's not a, I think it would be good. So you're going to run point on that?
I'll talk to him.
All right. Sorry, Senator Lee and then Senator Castle, go ahead.
I think there is a need for this legislation, but I want to make sure that we do it right. And maybe even give Josh time to go back and also if there any other committee members have any other issues in this legislation, maybe bring it to Josh in a time of, in the interest of time and efficiency, so we don't have to do this piecemeal. But I do like this legislation. I just want to go for it, but I want it to go right.
Council can help me with this one, but looking on page 4 of the reprint, on page 4, line 15 and 16, it says a personal delivery device may operate without registration on any highway, sidewalk, or crosswalk in the state. So does that mean that a county, municipality could not in any way regulate and say, well, no, none of those on this sidewalk, none of those in this area, none on this bike path? Is that what this means? Or have we taken away all local jurisdiction discretion to limit?
Yeah, that's correct. It would be for the period where there's a permit process, it would be in the MBA's hands, and then after that, there would be a general statutory authorization.
Yeah, my concern would be that a lot of us have these linear trails in our counties where you can pretty much cross the county on foot traffic or bicycle. And so if I'm running these things, I just pull up with a giant tractor trailers, and there's 6 different companies operating them, and you just use the cross-county bike trail as your main artery for these things, and it becomes sort of a mini transportation network. I'm troubled that we would take away discretion of local jurisdictions who currently can say, you can't ride bikes here. Right now they have discretion. They can say no bikes allowed here, no motorcycles allowed here, no push carts. They can restrict all of those just in the interest of how crowded a sidewalk is, how busy it might be in that area. And to take away that discretion just for this seems problematic.
Point well taken. Okay, so Bill, we're going to go on to Senate Bill 832, Charles County Senators multifamily dwelling registration fines and fees.
This bill authorizes Charles County to require a property owner of a multifamily dwelling to register the dwelling with the county in order to offer units in the dwelling for lease. Number two, it also authorizes Charles County to charge a fee on a property owner for the registering of a multifamily dwelling with the county. And three, it also authorizes the imposition of a fine on a property owner that leases a unit in a multifamily dwelling that is not registered with the county. The bill also authorizes the county to adopt regulations relating to the registration of multifamily dwellings.
Further discussion? All right, so motion for a favorable, I'll second. Is everyone okay? All right, great. All right, we'll now go on to Senator Waldstreicher, Senate Bill 862.
Senate Bill 862 authorizes a district court judge or a circuit court judge on a finding of good cause to recall an arrest warrant issued by a district court commissioner and instead issue a summons in its place. Under current law, a district court commissioner is authorized to issue an arrest warrant only if the commissioner finds that there is probable cause to believe that the defendant committed the offense charged in the charging document and the defendant previously failed to respond to a summons or citation, the defendant's whereabouts are unknown, and the issuance of a warrant is necessary to subject the defendant to the court's jurisdiction. The defendant is in custody of another, the defendant is in custody for another offense, or there is probable cause to believe that the defendant poses a danger to another person or to the community.
So I support the bill, but this is probably not necessary, but I feel compelled to say it. There's a lot that this bill highlights that's problematic in our system between commissioners and judges. For one, the very idea that any judge would be so ill-informed that he or she could not recall a warrant issued by a commissioner. But that leads us to this other huge problem that at some point we really need to address, which is the outrageous amount of power that we put into the hands of commissioners that have no law degree, that have no judgeship, that are appointed to nothing, and quite often very, very, with just a great amount of disparity, make determinations to begin with about where a warrant should be issued and where a summons should. And basically, we hear people say all the time that any random person can walk into a commissioner's office and come out with a warrant, basically because they showed up there. It's a real problem in our system. This is probably not going to be the bill where we're going to fix that problem, but I really implore us to do something about this. And if we really want to fix our system of pretrial and our criminal justice system, we can't do it if we leave this giant elephant out there that is a real problem with getting people off of oftentimes just, not always legitimate probable cause, locked up. And then, having to face a judge and having to possibly stay in jail awaiting something that is frivolous and not good. It happens a lot. It happens a lot amongst people that know each other. It happens a lot amongst friends that are mad at each other, people that are living in apartments together, people that are in intimate relationships. And I know this because it's the most common thing, I think, that causes people to get arrested. So that being said, I get the point of the bill. I think that whatever judge in Montgomery County didn't understand that he had the power to do this probably needs to be questioned about that. But nonetheless, I support the bill. But I also just want to lay the foundation that we've got to do something about this power of commissioners and the way that they issue warrants on people and cause them to be locked up and oftentimes for nothing. Thank you.
Sure. Yeah, no, I just wanted to agree with Senator Carter 100%. 100%.
I just want to note for the record that apparently it's okay to use the masculine form of a judge if he screwed up. So I noted that one. Thank you.
There are no amendments before us, so we make a motion for favorable.
Second.
Is everyone okay? Great, the bill passes. Now we are on to Senator Jackson with Senate Bill 874. Did we do this already?
Yes, but
Oh, that's right, that's right.
So there is an amendment in your packet after the voting session earlier this week. It was brought to my attention that really it needed a technical amendment. Basically, this would go back and into the bill that was passed last year, which was House Bill 1336, which actually contained a provision for this work group. But because of the veto and the override, the dates for that actually no longer made sense. So what this does is it takes the language from what the committee did earlier this week, and in that bill, and transposes that into the existing chapter law from House Bill 1336. And that really is just an adjustment of the dates.
I guess I would ask the vice chair whether it would be appropriate, given our recent discussion with the chief judge of the district court, whether we would amend this bill to provide for, instead of partial expungements, to extend the work group to expungements and blocking or shielding in a general form, rather than have two different work groups.
Yeah, so I'll defer to the sponsor of the bill on his intent. I think after our discussion with the judge, it is my preference that we have a vote on SB 201, and I'll make some amendments related to that. But nonetheless, I think it's completely advisable that beyond what we do in SB 201, if we do anything, that we take a broader look so that we're not doing this piecemeal every time on shielding, expungement, and partial expungement. Clearly, partial expungement has to be the core of this because that's been the most problematic thing to fix, as Senator Carter knows well, and I'm with her on it, on her goals. So I'll defer to the sponsor of the bill, but I think it could be advisable.
So I think I missed a little bit. I was sort of speaking in class over here. I didn't really hear what Jamie mentioned. Jamie, did you mention that there was an issue with the bill, the way it passed, the way we?
No, it was so last year. The General Assembly passed House Bill 1336, which actually contained a provision for this work group. But they never actually formed because the bill was vetoed, but then subsequently overridden.
Gotcha.
So what this does is that what was overridden will become law. I believe it's March 14th. But the dates for the work group, the due date of the report, their sunset, no longer work just based on where we are with the law becoming effective. So what this does is it goes back in and alters those dates. It makes a couple of other changes too, just to conform it to the language of the bill that, as it looked when you introduced the bill and with the amendment that was adopted earlier this week.
Okay, I'm good. It does what it needs to do in that regard. I do know. Well, I'll move the bill as amended, or.
I'm sorry. What, Senator?
Do I need to accept that amendment?
We need to vote to recommit it.
Well, it wasn't reported out, so you would vote to reconsider the bill, and then you would adopt the amendment, and then vote favorable as amended, or that would be the motion.
All right, is everyone okay reconsidering the vote? Okay, great, it's back here with us. Is everyone okay with the amendment? Great, the amendment's adopted. Now the bill's before you as amended. Senator Jackson.
I'd move the bill as amended.
Second. Is everyone okay?
So just to be clear, so we're going to have
So we're going to end up with two work groups. If, based upon the discussion we had with the chief judge of the district court, we're looking at a work group to look at blocking, shielding, and expungements, and then another work group to deal with just partial expungements. And those will be two separate and distinct work groups who will work in isolation from each other. But I just don't want people having unnecessary meetings and crossing swords. We see this too often around here where two work groups are kind of bumping into each other.
So,
look, I'll defer. I just
No. I think, yeah, I guess what I'm trying to figure out is how far along are you all with that conversation? I don't know if that's have you completed your?
So he outlined for us where he was based upon the laws that went into effect, such as the veto stuff, and what stuff is coming into effect and when it's coming into effect, as far as the court being able to block and shield and expunge. I don't want to step on anybody's toes. I'm only suggesting, for the matter of efficiencies, that in our discussions, generally we felt that these concepts of blocking and shielding and expungement are inextricably entwined, and that oftentimes people want expungement, and then you find out that all they really wanted was blocking, and blocking is really easy and cheap. It's just a matter of getting a computer programmer to put in a few extra lines of code, and blocking is done, versus expungement, which means people all across the state have to go in and pull files out and shred the files. So, and the chief judge was very interested in participating in a work group so that we can come up with because a lot of the stuff can just be done by his policies. If he comes up with a policy, says we're going to do this by this date and this by this date, if we're all happy with that policy, we just bless his policy and go home. If we look at his policy and say, well, listen, we're just not satisfied with that, we want to push harder for some reason, then I guess we could do that.
I think you're absolutely right, but I just didn't know if, I think it's Senate Bill 201 or whatever it is that you guys were discussing. I didn't know how far you all got in your discussion with Chief Judge, but if you all are ready to move that, then, I mean, I'll defer to the Senate sponsors.
Well, I'll let this.
I think it makes sense, though. I think it makes absolute sense. But
Yeah, I mean, I'll let Senator Wallstreicher was the lead of that, so I'm not going to inject. I'm just reminding people and throwing out ideas. So I don't want to squash anybody's bills or anything. Believe me. Thank you.
So just to reiterate, I'm fine with the slightly larger scope of this bill, but it's not my bill, it's Senator Jackson's bill, so I'll defer to him. If we were to broaden it out, it wouldn't alter the composition or anything like that. You would just change essentially the title of the bill, which would change a little bit of the scope. And that would change the scope in the purpose paragraph. But I don't want to do damage to the bill. It's a decision for the sponsor.
I just have a genuine concern about that because I was asked to run the bill because of what we're doing in COVID, and and I'd like to confer. I don't think the idea is bad, but I don't think I would want to say yes, and the true maker of the bill is not. So.
do you want to? I mean, I'm sure we could fix this somehow later down the road. But do you want to just run with the bill now, or do you want to check with your cross file, or how do you want to proceed? It's up to you.
I like to run the bill, get it done. I mean, we've recommitted before, right? Just to do,
That's fine by me.
All right, thank you.
All right. Is everyone okay voting the way you did before? It was unanimous? All right, great. So look, with that concludes our voting session. We're going to do, hold on one second. 672, are we coming back to that yet? All right, so let's go back to, sorry, so now we have our law enforcement folks, sorry, one more. 672.
So do you want me to?
So when we talk
Mr. Chairman, do you want me to reintroduce the bill or just go? All right, so just very briefly to reintroduce the bill expands mandatory participation in the Ignition Interlock System program and makes various technical and conforming changes.
Interlock, even for the typical first-time DUI offenses that result in a PBJ, right? And that's something that I think I have trouble with. Is that correct? That's correct?
Outside of the trouble with part, yes, that's
So,
correct.
you know, briefly,
Yeah,
I
go
was
ahead.
hoping we were going to, see, Mr. Chairman, you had it right when you said that concludes our voting session. But, so I know that there's a lot of empathy for this type of situation, and, you know, we don't want people driving drunk. No one does. But we elect and have appointed people that wear black robes on district court benches for a reason, and circuit court benches. And cases should be determined on an individual basis, and judges should have a discretion on whether or not they choose to order an interlock or not. Now, a PBJ, we might have changed it. I'm not sure if we passed the bill or not to change it that requires an underlying conviction. But this is the only area of our law of which I am aware that when we have a probation before judgment, it is never, for the course of eternity, able to be expunged. The only area of the law, we get a PBJ, it could be 50 years ago, it is never, ever able to be wiped off the record. That is punishment for people. Like, that's bad. That's terrible. It's enough. Not everybody is a repeat drunk driver. More often than not, in my experience, more often than not, there are people that are often, not always, but often young, stupid, get drunk, drive. It happens to a lot of people. They move on beyond it. The one-time experience of getting their car towed to the tow yard and having to pay $300 some when they get released from the central booking or the detention center in the county or whatever to get released. They spend a night in jail or some time in jail. They get their car. Then they have to get a lawyer. They got to be embarrassed around their family, their friends, their parents. They go to court. And more often than not, if there were no injuries or no accidents, the result is a probation before judgment because the courts say, hey, you did a stupid thing. We want you to, never do it again. But if you can stay out of trouble, if you can go to get an alcohol evaluation and a screening and evaluation, go through a program, we'll let you keep the PBJ. You go on with your life. An ignition interlock is usually reserved for cases where the court has reason to believe the person may actually be a problem drinker and they need a little bit more supervision. That should be up to the discretion of the court. In addition to that, we've spent a lot of time this session through various people's bills, the vice chairman's bill, Senator from Baltimore County's bill, even I have a bill that talks about these kinds of fines and fees. And so it's not cheap, inexpensive, or free to get an ignition interlock. So once again, we're putting people that don't have the money in a posture where they're not going to be able to drive and go on with their lives because they can't afford this ignition interlock. So for many, many reasons, I think this is the wrong way to go. And I certainly understand, the concern about these repeat drunk drivers. I don't actually believe forcing ignition interlock on a first-time PBJ is a solution to that, because I don't believe the majority of people that are get a PBJ and a first time, I don't think the majority of them repeat. But I also don't believe that forcing them to get an ignition interlock is going to stop that. And then I'm also thinking ignition interlock is for the very short and succinct period of probation. It's not for the next 10 years. So people who do recidivate, I'm fairly certain a good number of them are not recidivating within that 7 months, 10 months, 18 months, 12 months probation. So the ignition interlock isn't going to solve that. They're going to do it later on. So for all of those reasons, and because I deeply believe that we have got to keep discretion in the hands of our judges wherever possible, that's why we have them. If we're going to create these formulae for what is going to happen then why do we even need that person on the bench? Why don't we just say, DUI, PBJ, get ignition, interlock. We can bypass the entire court system. So I would urge the committee to take that into consideration and reject this bill. I move unfavorable.
Thank you, Mr. Chairman. So there are a couple of places where I agree with Senator Carter fully. The first is I, like you, find it abhorrent that PBJs for DUIs are not expungible. And I will be the first person to co-sponsor legislation to change that. Absolutely. As an ideological matter, I don't believe that PBJs are convictions. And the fact that they are not expungible is an embarrassment, and we should change it. You don't have to believe that a PBJ is a conviction in order to support this bill, because what this bill says is that an interlock is simply a condition of your probation. And if you successfully complete the probation, then you get it, then there is no conviction at the end of that process. Here's an interesting statistic that I found shocking. For people with an interlock, under current law, last year there were 3,800 attempts to start a car drunk, where the interlock intervened to prevent a drunk driver from driving. These are people who have already gotten a conviction and already got an interlock, and the interlock saved their life and likely the life of one of your constituents or your family member or your children. Another thing I agree with Senator Carter on is this only works if people who cannot afford the interlock have assistance. But we're very fortunate that the MVA has a fantastically robust financial assistance program associated with interlocks. Part of the burden sometimes for people who are poor is all the paperwork and stuff you have to fill out in order to get assistance. But for interlocks, the MVA makes it easy. They allow people to essentially get the benefit by proxy. So if your child is eligible for school lunch, you get the benefit. You have to pay almost nothing for your interlock. If you're on SSI or SSDI, you get the interlock. There's no form, if you're already eligible for a federal or state program that assists people who are low income, you automatically get into the MVA's program. The MVA's program primarily has to do with the operating costs, in other words, the monthly cost associated with the interlock. But now what the MVA is doing, and the manufacturers are joining in, is waiving the installation costs. So not only are you getting a dramatic break on the monthly cost, you don't have to pay anything to get it installed. You don't have to pay anything when it's taken out. And so I'm not one who supports the criminalization of poverty. I join you, Senator Carter, and wouldn't have put in this bill if I believed that this was a punishment for youthful indiscretions or a punishment for poor folks. That's just not what I do. I think this is a good bill. I think it'll save lives, and I move the bill.
I was going to say, I share the concern in that these are a PBJ, which we're not supposed to be treating as a conviction, and now we're going to pass this bill, which does have a mandatory punishment on it. And second off, I've shared this on other bills when we went to add a camera to ignition interlocks, and I said it was going to increase the cost, and I told the story about a couple years ago when my car broke down, and I was sitting in the auto shop all day while they fixed it and did all this work to it, and all day I was watching people come in and out, all day. It's not just the money, it's the time. They have to come in like once a month, get these things checked out, they pay something. So we have done, as I've been on other bills, when we start treating PBJs as if they're convictions and have mandatory sentences on them.
No, I share the concern that was raised by Senator Huff, but one of the other things that and looking at the Office of Attorney General's letter of support, it said, I mean, and I'm curious, were these comments taken into consideration, where it talks about no exceptions for low-income Marylanders and out-of-state drivers, and the rest of their comments? This, however, notes that the bill does not include any exceptions for low-income Marylanders and out-of-state drivers. The proposed bill does not consider how the program will be administered when an individual does not own a vehicle or if a driver is an out-of-state driver. And the office urges this committee to consider these exceptions and to amend the bill accordingly.
So I would just say that there's no difference between this and current law. So someone could get an interlock under those circumstances under current law. Those concerns are concerns that are applicable under current law and don't change under this bill.
And would you mind just addressing Senator Huff's concern about the treatment of PBJs?
Well, I'm happy to, and I would just say, again, I agree with Senator Huff. PBJs are not convictions. The interlock is not punishment. It's not. There are lots of ways to punish people. Fines, jails. It's not a punishment. It's a condition of probation. We utilize conditions of probation all the time. So, you can't do drugs while on probation, or you can't be out past certain hours on probation. That's not designed as punishment. That's simply a condition of probation. We don't say that's part of their punishment. The probation is designed to be a testing time period where you can show your rehabilitation through certain actions. And this interlock ensures that people don't repeat the mistake they made that got them into trouble in the first place. It's not punishment. I don't believe it's punishment.
Thanks. I'll be brief, hopefully. So, it depends on how you define punishment, but I would just argue that, if I could afford something, it wouldn't really be a punishment, but if I couldn't afford it, it might be. I'm thinking back to when I was young, and even when I wasn't so young. I was never on any of those government programs, but it still didn't mean that I had any extra money. And yes, I'm not saying that, there shouldn't be some type of consequence for what you did, but generally, if you are already put on probation, you already have a probation supervision fee. If you are fortunate enough to be able to get money together to hire a private attorney, you have that attorney's fee. And so and you have court fines and costs. You're always ordered to pay these court costs. Here's the thing. Right now, a judge could assess a situation, an individual in a situation, and say, hey, you know what? I believe, based on everything I know here, there's actually no threat of this happening again. I'm going to give you a PBJ. Nothing happens in a certain amount of time. It's off your record. Or a judge could say, hey, I'm going to give you a PBJ, 12 months of supervised probation under the drunk driving monitor program. You're going to have drug screening, treatment, evaluation, and treatment, blah, blah, blah. People that get private attorneys, and I can speak for myself, is what I do is I say, to prepare for court, and this isn't going to, we're not deciding right now if you're going to be guilty or not guilty, to prepare for the worst case scenario between now and the court date. I need you to go into a program. I need you to be evaluated. I need you to get treatment. So when you walk into court, if it winds up being any type of a conviction, you can present to the court. I've already been through counseling. I've already been through treatment. I've been assessed as not a likely repeat offender, not having an alcohol program or need. And if I do have a problem, then I'm now being treated for it. So that oftentimes would obviate the need for an additional period of supervised probation when they walk into court like that, and that's how I always advise everybody to walk into court. But then to have to take an additional, you've already got like probably the 12 months or so, or almost, with COVID, longer than 12 months, between the incident and the time you go to court. Then you go to court, and you would have this other imposition. And so I think that what is the case is that you are prescribing with this bill what the judge must do in a PBJ, and that is the problem. The judge no longer has the options to make different decisions in entering a PBJ, and so that is my problem. And we really do need to examine, our position on judicial discretion and our position on probation before judgment. It's kind of, this is taking us back in a direction that I didn't think we were going. So I would urge us to vote unfavorable on this bill. I just don't think it's necessary. And I actually think, there may be some benefit to this. I mean, there may be benefit to having every single person, when they get their license with the MBA, get an ignition interlock. Then we'll never have anybody driving drunk. Like, that's probably a really, wise thing to do. But we're not going to do that. And so, to me, to just kind of like randomly say, because you've got this one incident, that now you've got to have it, I don't think that's really a fair way to go. I think that leaving it up to the court is the better way to go. And Senator Castley just said in one of the previous bill, hey, I don't know if this is the right thing to do, but let's let the courts deal with it. So let's let the court deal with it. That is what the court is there to do. Thank you.
Area of the law that I practice, either Senator Carter or counsel, that if you do get a PBJ, as a condition of probation, the court would have discretion to require ignition interlock. Is that? Yes. I'm sorry. Is that a yes? Yes. Okay. So what the bill would do is say, but you don't have. We're taking discretion away from the judge. You can't. They could say get it if they thought you needed it. This says no. You got it no matter what. Yes. Okay. Thank you.
Further discussion. Senator Lee, go ahead.
Excuse me. Jill, are you saying that it should not be a mandatory as a part of PBJ? That's what you're saying?
I think it shouldn't. This bill mandates it in all first-time situations, and I'm saying it should not be mandatory in all those situations. It should be discretionary based on what is presented to the court. The court could decide it's not necessary, or that, frankly, under the circumstances, it's not necessary and the person can't afford it.
But you're saying the judge can still order it as a condition?
Right now, the judge can order it, yes. Generally, I'll be honest, in a first-time offense, when there's no accident, there's no real excessive amount of drunkenness, and the person comes in, presents, has a good life, and they've gone through some steps, generally the judge is not going to order it in a first-time PBJ. But if the judge has reason to believe this person can't really be trusted to not drive drunk, the judge will order it in a first-time PBJ.
So I don't want to belabor the debate, but we keep referring to this person as someone who's driving drunk for the first time. As Senator Huff noted in a previous bill, we know it's not the first time. It's the first time this person has gotten caught. And so a lot of folks who are on their first offense have driven drunk multiple times. And the next time could be your family, could be your constituent. Just because they got caught the first time doesn't mean they're not doing it more frequently. That's why this is so important.
I was just going to talk about where we've, on this bill, I mean, we've done a lot. I've voted for a lot of these, but I've also had concerns. I mean, we used to only do ignition interlocks on we called them the super drunks. So you blew a .15. Heck, I think, I may be confused, but I thought we lowered the limit on these down to .08, and we had a real concern about going to .08 because it was like, I think it was Chris West that did the math and pulled up like 150-pound, 120-pound person. It could be 2 drinks hit you on a .08. So a judicial discretion may look at it and say, okay, I had a young lady coming from a Christmas party and she had 2 drinks, but this person's not an alcoholic. I don't see that I need to put an ignition interlock on the car and all that. It's a judicial discretion. So, like I said, I think we've gone from only putting these on super drunks to now, if we do this, doing a mandatory sentencing on all PBJs. I just think that's a bit much considering everything else we've done on the law.
No, but well, there was a motion, then there was a motion for favorable, it would have got, and it got seconded here, so, but we're gonna hold it. We're gonna hold this. Unless you wanna run it now, like roll it.
It's a favorable motion.
All right, we'll see. It's the same thing. Look,
That's fine.
you just gotta know which way.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
Wait, what are we voting on?
This is a favorable.
I thought we were holding this.
No, we're rolling.
Can you come back to me? Okay.
Senator Castley.
Yeah, look, I voted for every interlock bill coming up through this committee. I've just reached a point where I think we've maxed out. I'm going to vote no.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
I think I'm for judicial discretion in this one. I'm going to vote no.
Senator Jackson.
No.
Senator Bailey.
No.
Senator Carter.
No.
Senator Huff.
No.
Senator Lee.
Yes.
Yeah.
All right. Bill fails. All right, so tomorrow morning, we'll get back here. We've got 10 o'clock. So we're going to vote at 10 o'clock. We're going to start off with Senate Bill. Where are you, Senator Kelly? We're going to start off with Senate Bill 202, and then we're going to move to Senate Bill 98. And those will be the first two bills we take up tomorrow. All right, thank you all very much. Yeah, and we'll do the PG. Yeah. Yeah. Take it up tomorrow.
All right, so you're out. Okay.
I'm just gonna go to my Zoom. I'm
Okay.
missing like it's like her acceptance thing.
Oh.
There's like an acceptance thing.
That's a big deal.
I found the one group. That's the one group we can stand up here. They have no swings, John. That's the one group we can kill their bills. Till next year, it's a little. That was a good one. You know, the more I thought about it, I want to interrupt you with that because they have.
Oh. Yeah,
It didn't go through for some reason.
Yeah, that's because I'm in this room.
Oh. Do you know what the front of it was for 691?
Yeah, give me just a second.
Okay.
They have gone from everybody to.
I also know other people share a picture with you. You know what I mean? It's a mix.
Well, now we all owe Jeff. Now we owe him a lunch.
I know. Hey, Jeff, I'm sorry. We owe you dinner now.
You don't have to apologize. We're not live.